special meeting of the Code Enforcement Appeals Board. And we're gonna start first with a roll call. Matt, are you doing the roll call or are you doing?
Sure. We could just start at one end and work our way through.
My name is Kyle. I am facilitating this meeting.
Okay.
Matt Luttrup, Engineering Services Manager for the City of Lafayette.
Plain board member.
Jennifer Paul, Chair.
Greg Moronic, board member.
Yvonne Lynn, friend of the Haynes.
And business owner.
Oh, and business owner, yes. I have built a lot of businesses around here.
Bennett Payne
And Ann Payne.
and our three kids.
Terrific.
You would have public comment.
Yes, I was a public comment.
So we have all three of, just noting that we have all three of our board members here.
Who's on?
Oh,
Oh,
yes,
we gotta
yes,
introduce
please, let's do
her.
introductions. Thank you.
Aaron, do you want to start?
Just introduction.
Yeah. Hi, Aaron Chandler on behalf of the Code Enforcement Division of the City of Lafayette.
Gerardo?
Hi, Gerardo Jimenez, previous code enforcement officer for the city of Lafayette.
Good morning. I'm Sarah Laughlin, attorney with Best and Krieger, representing the board in this matter.
Great. I'm sorry, attorney with whom?
Best Krieger.
Oh, okay.
Great. And I want to move to the adoption of the agenda, but before I do that, I just want to double check. Does staff have any additions to the agenda other than what's been already submitted?
No.
Okay. Seeing as there are no additions to the agenda, I just wanted to, somebody make a motion.
Move to adopt the agenda.
Second.
Great. All in favor of adopting the agenda? Aye. Great. Okay, motion passes. Agenda has been adopted. Great. Are there any public comments for items not on the agenda? Any? Nope. Okay, great.
What is the agenda? Do you guys want to just,
Oh, the agenda,
Share the agenda.
it's the hearing itself
Okay.
is the agenda.
okay.
So if there's something other, sometimes people can come to a meeting and you are allowed to speak on any public can come about anything for this board.
Okay.
Yeah, great. Okay, so seeing that there's no public comments on items not on the agenda, we'll get to public comments later for the agenda. Then I wanted to open the hearing officially. And I know that we have already started with introductions, which is great. We will go ahead and we're going to hear from the Paynes, and then we'll hear from our side, from the staff.
Aaron, is that normally how we do stuff where it's does the city go first or the appellant?
The hearing board can dictate
Okay.
however they want to go. So I'd ask Sarah to,
We
comment on that
actually
for them.
didn't bring these cases or citations or whatever. Our expectation is that the city should go first
Okay.
and then we'll respond to that.
Fair enough.
And just one procedural question, is this, I assume it's all recorded, will we have access to the recording after the fact and,
Yeah, and talking to Therese Kane, who's the engineering admin assistant, she says it should be ready in a couple hours or so after
Oh,
the
great.
meeting.
and is that emailed out to us or how do we? access?
I'll see if she can email it to you. Chances are the file's gonna be kind of big, so our email server gets angry if we try and send something that large.
Uh-huh.
But I suspect it would be put on the website.
Okay.
And then it can be downloaded, but I'll ask Therese to send you a link to
Okay.
that, so you don't have to play Where's Waldo with it.
Yeah.
That'd be great, thank you.
You bet.
Okay, great. Then we will go ahead and start with the city to do a presentation.
Oh, wait,
Sure.
one last thing
Yeah.
is I noticed that no one who is part of our folks, any of our friends and neighbors are on this Zoom link. Just want to make sure that well, it could be that they didn't get the link or something like that, but
So there's 12 people on this call. Dan Davis, Jean, Jim, Joanne Munoz, Joan Robbins, Samsung SM731, Veronica McAllen,
Okay.
and Whitney Ahern, Simon. They're just not on the video here.
Oh, okay. All right, got it.
Just want to make sure they were able to access it. Thank you.
Yeah, they're on. Okay, so are we okay to start?
Yep.
Okay, I'd like just to give a brief statement, just to narrow down, I think, what the issues are here, and then get into the testimony of Code Officer Jimenez. When we're looking at these types of issues, at least per the code, we look at the duration of the violation, other related violations, seriousness, good faith effort to correct, and then other factors that may be affected. And in this particular situation, we had an outstanding violation for trash, debris, overgrown vegetation. There were notices sent. That violation has since been corrected. However, due to the duration of the violation, it took some time to get corrected. We have the issue of the unpermitted gas line. Again, that was a issue that required a permit. That took over a year and 9 months in order to obtain the permit after the first notice. So again, the duration was quite long. The seriousness, obviously, gas leaks, gas explosions, things of that nature relate to the seriousness. And then obviously the good faith effort goes back to the notices and the time frame in order to get that done, along with effects of how that could affect neighbors if something did in fact go wrong. The final issue was the unpermitted accessory structure. Again, in 1991, it was permitted for a carport and a workshop. Again, it's the city's position that there's been unpermitted electrical, unpermitted plumbing, and then again, unpermitted construction and closure of the carport. And again, that is outstanding, at least 1 year and 10 months from the first date of notice. In regards to these issues, again, it's the grading issue and the accessory structure. The home itself, the main residence, is not in question here. And I would just like to point out that all of these issues can be corrected, can be permitted, and we've let the Paynes know that, and we've let their prior council know that. And I think at this point it's just the refusal to get these permits for what's been happening here. So with that, I would like to start by calling the city's first witness, Gerardo Jimenez. Can one of the and I request that all testimony be under oath. So if there could be somebody from the board that can swear Mr. Jimenez in.
Also, we got a bounce back from Gerardo when we were sending an email to him. Gerardo, do you still work for the city? What is your role at this point?
I'm not employed with the city of Lafayette anymore.
Oh, okay. All right.
Okay, yes, I can administer the oath. You ready? Okay. Do you solemnly state that the evidence you shall give in this issue shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Mr. Jimenez, were you previously employed with the city of Lafayette?
Yes,
And how long were you employed for the city of Lafayette?
approximately a year.
And what was your position at the city of Lafayette?
I was the code enforcement officer for the city of Lafayette.
And prior to the city of Lafayette, where were you employed?
I was with the city of Huntington Beach as their senior code enforcement officer.
And how long have you been a code enforcement officer?
In total, we're looking at 9 years.
And part of that, have you done training to be a code enforcement officer?
Yes.
What type of training did you do in order to become a code enforcement officer?
Through the California Code Enforcement Officer Association, there's a multitude of educational programs and certification programs that we are required to take. as well as the Penal Code 832 under the California State Organization.
Okay. And you understand that today we are here to talk about an appeal related to citation 342 and the notice and order that was issued on December 16th, 2025?
Yes,
Okay. During your time at the City of Lafayette, are you familiar with the property located at 3400 La Caminita?
yes,
Did you inspect this particular property?
I did. Yes,
Have you spoken with the owners, the Paynes?
on a few occasions. Yes,
Okay. And through your enforcement, did you document most or all of your enforcement action against this property?
yes,
And that's by taking photos,
yes,
drafting notes,
correct.
issuing compliance notices,
Yes,
and issuing citations?
yes, correct.
Okay. If I could share my screen, let's see. One second. Yeah. See if I can share my screen. All right, let me see if I can share my screen here. Can everybody see the code enforcement appeal form?
Yeah.
Okay. So this is the appeal from the Paynes regarding citation number 342 and the December 16th, 2025 notice and order to repair. Have you seen this document, Mr. Jimenez?
I have. Yes,
Okay. And did you issue citation number 342?
yes, I did.
Someone's trying to break into my room here. Let's see. Can everybody see the administration citation number 342?
Yes.
Okay. All right, I'm gonna, this was issued on December 12th, 2025. Did you issue this, Officer Jimenez?
Yes, I did.
Okay. And so looking through the citation, this is on page 1 of 4. There's a grading violation, a building code violation, hazardous mechanical, grading permit violation, junk and debris, overgrown vegetation. And then starting on page 2, hazardous electrical, hazardous plumbing, and then ADU or zoning violation. Do you see that?
Yes. you see it.
No,
Officer Jimenez? I'm asking Officer Jimenez.
Yes, I
Sorry.
It's okay. Did you create this citation?
Yes, I did.
Okay. And then again on the middle of page 2 of 4, there is a red print that says correction required by January 11th, 2026. Total fine $9,000. Do you see that?
Yes, I do.
Does that mean that if they correct it by January 11th, 2026, that the total fine of 9,000 would be imposed?
That is, well, we have the ability to be able to waive the citations. That could have been an option if we obtained compliance by that time frame.
Okay. And is it your understanding that they did not correct these by January 11th, 2026?
Correct.
Okay. So I would like to talk about just briefly the violations regarding general junk, vegetation, and overgrown vegetation. These have since been corrected. Is that your understanding?
My understanding, yes.
Okay. Do you recall the date that you first notified the Paynes that there was a violation of overgrown vegetation, property junk and debris on their property?
If I have a moment to review my notes, I could probably find the date.
Yeah,
but
please.
I don't recall.
Yeah, please.
On approximately October 1st of 2025, we were notified of an additional complaint regarding dead vegetation and junk and debris along the rear of the hillside.
Okay. And you said this was an additional complaint? Was there a complaint prior to that?
The previous complaint was the case that was already existing regarding the grading violation as well as the gas line. We received an additional complaint for the junk and debris as well as the overgrown vegetation in October.
After that complaint, did you try to inspect the property?
I inspected the property from a neighboring property from their rear yard adjacent to the hillside where I was able to observe the violations that were reported.
Okay, so after you inspected the property, observed violations, did you send a notice to the Paynes?
Give me a minute to check my notes to see if I sent the notice of violation. It looks like it just went into an amended citation for the two violations.
Okay, and was that on October 2nd, 2025?
That is correct.
Okay, so you notified them on October 2nd, 2025. Did you again inspect the property for overgrown vegetation or junk and debris on another date? On November 14th, 2025?
Yes, I did.
Okay, and then you issued them a citation number 326 on November 14th, 2025?
Yes, I did.
And then you issued them again another citation on December 4th, 2025?
Yes, I did.
And then you issued them another citation, which is for this particular appeal, which is a citation number 342 on December 12th, 2025. Is that correct?
That is correct.
Okay. So we at least from October till December, they failed to correct those violations.
That is correct.
Do you recall when they finally corrected the trash debris and junk?
I do not recall.
Okay, I would like to move on to the gas line violation. So here we have an unpermitted gas line that requires a permit. Is that correct?
That is correct.
And do you recall, per your notes, the first time that the Paynes were notified of the unpermitted gas line?
Looks like they may have been notified in May of 2024 by the Contra Costa County during the time that they were notified of the grading.
Okay, so May of 2024, they were notified by the county inspector. And per the municipal code, they're required to obtain permits for this, correct?
That is correct.
Um, Per your recollection in your notes, did you issue any notices regarding the um, unpermitted gas line?
If I recall, I believe I sent two notices regarding the issue.
Okay. And you also sent an administrative citation for the unpermitted gas line?
That is correct.
Do you recall how many citations you issued for this particular grading or the gas line violation?
Approximately 7.
7. Okay. And then were you aware that the city issued a cease and desist letter from the city attorney's office directing the Paynes to ensure that the property is in compliance with all local and state laws?
Yes.
And I'm looking at attachment 15 of the city's exhibits. It's a September 8th, 2025. Were you given a copy of this cease and desist letter?
I was given a copy, yes.
Okay. In addition to that, were you aware that the city issued a notice and order to correct all violations issued on December 16th, 2025?
Yes, I was.
And that is city's exhibit number 20. Legal notice and order to repair December 16th, 2025. And it lists all the violations regarding this particular property, including the unpermitted gas line. Did you receive a copy of this as well?
Yes, I did.
Okay. Do you recall when the Paynes finally obtained a permit for the unpermitted gas line?
The
Sure.
the
Go
initial
ahead.
permit was submitted in 2024 initially, but the permit wasn't finalized until sometime in 2025.
Okay. Per their statement, it's February 2nd, 2026. Does that sound accurate?
To have the gas line permitted.
Uh-huh. On or around that date, February 2nd, 2026.
That would have been after my departure, so I'm not sure.
Okay. Well, I'll
Right, that was when it was finalized, not when permit was issued. Is that correct?
That's correct.
Yeah, once it was finalized. Per their statement, it's February 2nd, 2026. So if that is in fact accurate, that was 1 year and 9 months after the first notice issued to the Paynes to make that violation. Does that sound accurate to you?
Yes.
And when we talk about the seriousness of the violations in terms of the gas line, there are certain requirements under the permit that need to be met. Is that your understanding?
Correct.
And so, and some of those issues could be the depth of the pipe,
Yes.
and then also possibly the whether it has the required sustainability for pressure. Is that accurate?
Yes.
So let me just see here. This is the position statement provided by the Paynes, and I'm going to look at an exhibit down here that is
While he's doing that, quick question, procedural question, because prior to coming, we actually sent out an email to try to get some clarity on the process and how this procedure works. Or
Sure.
the hearing works. We also, I believe our attorneys also had asked the same thing earlier this year in January, but we had not been able to get any feedback from the city on that. And so maybe this is a dumb question, but after Aaron finishes with Geraldo, are we to then specifically respond back to all of the questions that Aaron is asking to refute, since we obviously have different data that I think refutes virtually everything that's being shared right now? Or are we supposed to, like, what's the format?
We're
Or
it'll be that we're gonna,
or six-
we'll allow the city to present the
Yeah.
full case, and then you'll have a chance, and then we can go back, and then we'll eventually finally bring it back for a discussion among the board. And we can ask clarifying questions of both sides, of both parties.
Okay,
Yeah,
all right,
so
got it.
everyone will have a chance to say what they want to say, and then we will allow for the public comment as well, to have a chance for them to speak.
Okay, all right, got it.
Yeah.
Thank you.
Yeah, Mr. Bennett, unfortunately, we can't give you any legal advice in terms of how, we can kind of tell you what the process generally is, but we can't really give you legal advice.
We're not looking for legal advice. We're just trying to understand, if we're having a hearing, what the process is so that we can rightfully share our position
I understand,
in your format.
Yeah.
Yeah, I
in the
know.
format.
I certainly understand,
Yeah.
but some of that does implicate giving you some legal advice in terms of legal strategy to move forward with like a trial or a hearing. So,
No,
Well,
I
we're
don't think
asking
it,
that.
I don't.
So this,
Do you think that that's what we were asking, Aaron?
so getting into, I think, a discussion of the minutia of whether or not somebody was or was not asking legal advice is going on a tangent
Yeah.
that I don't think we need to do. I think that the question was, what's the format when you get the opportunity? The city presents its information and then you present yours. So, and I think that's maybe
That
what
was
you're
the
looking
question.
for.
Yeah.
So can we?
Yeah.
Yeah.
We
We're
can,
good.
we're good. We can continue.
Yeah, yeah.
okay, Officer Jimenez, I was talking about the issues with severity of an unpermitted gas line regarding depth of the pipeline to ensure that's deep enough, and then also the pressure testing to ensure there's no gas leaks or an explosion. Again, I'm looking at the position statement provided by the Paynes, and this is a document from Contra Costa County Building Inspector Fred Chapman. And there's comments in here. And I'm looking at the paragraph under documentation of the visit. And halfway through the first paragraph there, it says, we, the Paynes, again explained that we did not know that they needed to have a permit for this, given the gas lines were pre-installation and have never been or may never be connected. Do you see that?
I do.
Okay. And this is date of inspection on January 30th, 2026. See that?
I do.
It was your testimony earlier that you provided at least 7 citations and a notice regarding what's required to correct the unpermitted gas line, correct?
Correct.
Okay. Um, and if we scroll further down, I think it's the second to last sentence. We, the Paynes, reiterate that we may not even use this because we also have 4 solar panels. We also told Fred that this was simply for future use planning while we had not finished landscaping. Um, whether they intend to use it or not, it would still require a permit to be put in the ground, correct?
Correct.
Okay. Fred, who is the building inspector for Contra Costa County, said he will require 2 things. One, he will need to dig a hole to show the depth, as the inspector will need to see this in person. And 2, he will need to do a pressure test. Do you see that?
I do.
Okay. And these are all requirements that he would need to see whether it was done correctly. Is that accurate?
Correct.
Okay. And it's your understanding, at least from what I've provided to you, that the gas line permit was finalized somewhere around February 2nd, 2026?
Yes.
Okay. And again, that took 1 year, 9 months to get finished. Is that an accurate timeline?
Yes.
Okay. Um, I would like to move on to the violation regarding unpermitted grading. You have inspected the property in person. Is that accurate?
Yes.
Were you able to view the area of the unpermitted grading?
Yes, I was.
Have you been able to review photographs of the inspected area?
Yes, I have.
I'm going to look at city's exhibit number 4. This is city's exhibit number 4. This is the code enforcement case file, which includes notes and photos. And I am going to page 7 of 15 of this document. Can you see that?
Yes, I can.
There's 4 pictures on this page on the upper right-hand corner. It says 3400 La Caminita photo. Do you see that?
Yes, I do.
It looks like there's a structure to the right and a black vehicle, and then an area that looks like it has been graded. Do you see that?
Yes, I do.
Is this the area that's in question regarding the unpermitted grading?
That is correct.
Okay. Hmm. I would like to look at city's exhibit number 24. Um, yes, 24. This is exhibit number 24. This is a document, 9 pages that was submitted by the Paynes. Have you reviewed this document before, Mr. Jimenez?
Yes, I have.
Okay. And it looks like there's a scope of work, some comments here, and it looks like this is uh, uh, an application for, looks like a building permit for grading. Is that accurate?
Yes, that is it.
And I'm looking on page 2 under the scope of work. Here it says, and it looks like the second paragraph, it says approximately 45 cubic yards of natural hillside material, primarily competent sandstone bedrock with common marine shell. Impressions were evacuated over an area of 45 feet wide, 11 feet deep, and I'm assuming this is 5 to 8 feet high, not 58 feet high. Do you see that?
Yes, I do.
And under the code, what is the regulation regarding what initiates a permit to grade a certain amount? What's the threshold?
50 cubic square feet?
50 cubic square feet. And so
Yards. Yards.
yards. Okay. 50 cubic yards. And so when we do the calculation here, which is you multiply, you have to get the cubic feet here, right? So it'd be 45 feet times 11 feet, and let's just say 5 feet, right? You make that calculation. Is that accurate, Mr. Jimenez?
Yes, that is it.
Okay, so if you take 45 feet times 11 feet times, let's just say 5 feet, you get approximately 2,475 square feet, correct?
Correct.
Okay, then you divide that by 27 because this is per yard, right? So you divide that by 27 and you get approximately 91.6 cubic yards, correct?
Correct.
Okay, so this per
Gotta divide it
Yeah,
by
by
2
two.
because it's a triangle.
it's a triangle. So per their calculations, it's 45.83 cubic feet, correct?
Yards.
I mean, sorry, yards. I'm gonna confuse myself all day, right?
That would be correct. Yes.
Okay, and that's the lowest amount, right? If they use 5, correct?
Correct.
Yeah. Okay. Then we scroll down, it looks like page 6 of 9. And again, they have their dimensions here, right? Which is 45 feet in length, 11 feet in depth, and then somehow they can't narrow down the height, but somewhere between 5 to 8 slope. Do you see that?
Yes, I do.
Okay. I would like to look at the exhibit, and this is from appellant's position statement. And this is on page 38 of 102. This is Quantum Geotechnical Inc., October 1, 2025, and it's an evaluation of the cut slope. Do you see that?
Yes, I do.
Okay. And so it appears to me that this was not created by the Paynes, but this was created by Quantum Geotechnical Inc. Do you see that?
Yes, I do.
Okay. So this is no longer their calculations. This is a company's calculations. And the second paragraph, second sentence says the graded area consisted of cutting into an existing native slope over a length of 45 feet and a depth of about 10 feet. And then the evacuation created a rear vertical cut along approximately 6 to 9 feet. Again, for some reason they can't narrow that down. So if we take the calculations that they've provided here, it's 2,700. And then it's an angle at the lowest amount, right? And then you divide that by 2, that would create an exact 50 cubic yards, correct?
Correct.
Okay, and if we take that representation, or here they put 6 to 9 feet, so that would put them over the threshold in order to get a permit. Is that accurate?
Correct.
And it's your understanding that they have not obtained a permit for that, correct?
Correct.
Okay. And since the city notified them back in, is it your understanding that they were notified in May of 2024 of the grading issues?
That is correct.
And so it's been at least 2 years and 1 month since this has been outstanding.
Correct.
And if this is done incorrectly, as we can see in the city's photos, some of the issues that could arise would be that slope would fail. Would that be accurate?
Yes.
And that could cause property damage. If someone's near it, it can cause personal injury. Is that accurate?
Correct.
Okay. And the city's permitting process, which it has adopted, is to ensure that this is safe and to ensure that it's done correctly. Is that accurate?
Yes.
Okay. I would like to move on to the final issue, which is the unpermitted accessory structure that's on the property. Again, Officer Jimenez, you have physically been on property and at least inspected the exterior of this accessory structure?
Correct.
Okay. And during your last inspection, it was an inspection pursuant to a court-ordered inspection warrant. Is that accurate?
That is correct.
Okay. And when you tried to access the accessory structure, were you able to get in?
I was not able to gain access into the interior of the building.
Can you comment on why you were not able to get into the accessory structure?
The doors were locked and I did not have a locksmith on site to gain access into the dwelling.
Okay. And did you ask the page to open the door?
No, I did not.
Okay. Did they obstruct you in any way in trying to get into the accessory structure?
Not that I recall.
Okay. And so when you were on site, you were able to take photos?
Correct.
Okay. And were you able to at least kind of see inside the accessory structure?
Partially, yes.
Okay. I would like to look at Cities Exhibit 21. I have it up somehow. Tried to zoom in for everybody here. Do you see this document?
Yes, I do.
Have you reviewed this document?
Yes, I have.
Okay. And this is a 19-page document. I'm looking at page 2 of 19 now. Up here in the upper right-hand corner, it gives a description, a detached garage and workshop. Do you see that?
Correct.
So it's your understanding, and looks like that this is dated February 1st, 1991.
Correct.
Okay. Are you aware of any other permits that have been granted or finalized regarding this accessory structure?
Not that I know of.
Okay, so the structure that is on this property is supposed to conform to the requirements of this permit.
Correct.
Okay, and then, so any deviation from this permit, when we go through it, would require a, some sort of permit, whether it's electrical, plumbing, or building permit?
That is correct.
Okay. Now I'm looking at page 3 of 19 of this document, and on the bottom left-hand corner, it has cursive writing. It says garage accessory only, no kitchen facilities permitted. Do you see that?
Yes, I do.
Okay, so is that indicating that this is only supposed to be a garage? And then the workshop is to have no kitchen, or actually the entire thing is supposed to have no kitchen facilities permitted. Is that accurate?
That is correct. All right, let's see. I'm going to scroll down to looks like page 17 of 19. I think. No, one more. I'm going to scroll down to 18 of 19. This document shows a workshop plan, carport plan, roof framing. Do you see that? Yes, I do.
Okay, I'm gonna scroll into the workshop plan here. See if I can get a. Okay. So here it has notes on the workshop. Again, in cursive up here, it says no kitchen facilities permitted. Do you see that?
Yes, I do.
Okay, and so that basically means this particular workshop should have no kitchen facilities. Is that accurate?
That is correct.
Okay. And then if we go here, it has notes in print and it says note HVAC system, wall power outlets to be provided per code. You see that?
That is correct.
Okay. And when they put statements like outlets are to be provided per code, does that mean that they have to comply with the electrical code in order to obtain permits to put electrical outlets in here?
That is correct.
And in your review of the file, do they have any permits for electrical?
None that I could find.
Okay. And then it has, again, some cursive with a circle around it says to remain unheated, uninhabitable space. Do you see that?
Yes, I do.
Okay. And then on the bottom left-hand quarter here, they have WC. Do you know what that stands for?
Water closet.
So like a toilet, right?
Correct.
Yeah. And SH, you know what that stands for?
I'm not familiar with that term.
I'll represent, I mean shower. And then, do you know what WH stands for here?
Water heater.
Water heater. Okay. So, and again, we have toilet, the L represents sink, but a shower, again, they would have to have plumbing in order for these to work, correct?
That is correct.
And they would have to obtain um, plumbing permits, correct?
That is correct, unless if these were the approved plans and those features would have already been approved.
Okay. But in your review of the file, they don't have any plans on file for plumbing, do they?
Not that I recall.
Okay, and then if this was approved, right, for the plumbing, any additional plumbing, say a sink or a dishwasher or anything else, or a washer or dryer would require additional permits in order for those to be permitted here, correct?
That is correct.
Okay. I'm going to scroll down to the left, which is the carport plan here. And again, it's your understanding that this is supposed to be a unenclosed carport, correct?
That is my understanding, yes.
And they are allowed to have 2 rolling doors on an overhead track. You see that?
Yes, I do.
Okay. And it's your understanding that this entire portion is now fully enclosed, correct?
That is correct.
And that would require a permit.
That is correct.
And if they did obtain a permit for all this, it would be fine, correct? They just don't have the permits.
Yes, that is correct.
Okay. Then I want to scroll down to the bottom right, which is the carport section elevation here. And it looks like the workshop is over here to the right. Is that accurate? I think that's what that says. Fire tiered wood shape. I can't tell. It what is this particular area? Is this supposed to be the entrance to the car port? Do you know?
Looking at the plans, I'm not sure if that's supposed to be the entrance to where the cars are supposed to go.
That's fine. Just a few more questions. Let me see. I'd like to look at Exhibit 22. Actually, let me go back to Exhibit 21. You previously said, obviously, the wall power outlets are to be provided by code, and they have a water heater here. The water heater would require an electrical outlet, correct?
That is my understanding. Yes.
And if this was permitted, there would be that it could be that this electrical outlet would be approved if that was the case, correct?
Correct.
Okay, and then so any other outlet in this particular structure or this other structure would require an electrical permit, correct?
Correct.
Okay, all right. I'd like to move over to City's Exhibit 22. These are photos provided by the appellants. It looks like there's 12 pages, pictures on both. This picture here is titled Guest Cottage. Again, this was created by the appellants and it says permitted when we bought the house. What is your understanding, if any, Gerardo, that if a property owner buys a property, they take it in the condition that they buy it in, meaning if there's code violations and they buy it, whose responsibility is it to fix it?
The new property owner's responsibility.
Okay. And so I would just like to point out California Civil Code 3483 says exactly that, which is every successive owner of a property who neglects to abate a violation created by a former owner is liable in the same manner as the person who created it, which is the former owner. So again, that's your understanding in a code enforcement setting?
That is correct.
Okay. I'm looking at page 4 of 12, and this is a picture of the, I guess, guest cottage. Is this an accurate photo of what looks like the cottage?
Yes.
Okay. And we see here, at least on like this front door, we have a light over here. We have an electrical box down here. It looks like maybe a floodlight or something here. Those would all require electrical permits, correct?
If they weren't already existing, yes.
Okay. And it's your understanding from the prior plan that they weren't on the 1991 permit. Is that accurate?
Not that they weren't called out on the original plan.
Okay. And then again, This looks like the breezeway with electrical here. If these weren't already permitted, they would need an electrical permit.
Correct.
Okay. Just quickly. Um, Go back to Exhibit 23. Looking at Exhibit 23, page 12 of 15, top left corner here. Is this an accurate photo of what the accessory structure looks like?
Yes.
I'll try to zoom in here for everybody. It's a little pixelated there. So based on your review, which part of this is supposed to be the carport, or if you know?
Where your mouse cursor is, that portion near the basketball court. It's my understanding that's supposed to be the carport.
Okay, and it looks like it's now enclosed, right?
That is correct.
Okay, now and it looks like there's windows on there. Is that accurate?
Correct.
And so they would need a permit in order to do that. Is that accurate?
That is correct, yes.
Okay. Let me zoom out here. And I'm looking at page 12, the photo on the right-hand side. I'll try to zoom in here. This is the interior of the front. Is that accurate?
That is correct.
Okay. And so, my apologies. Let me, my apologies. Let me pull up, let's see. I can just have 1 second here. Let me see. Okay. This is City's Exhibit 23. Looking at page 12. I might have asked this, sorry, but this is a picture looking into this cottage, correct?
Correct.
Okay. And in this photo, looks like there's some sort of table here. Do you see that?
Yes, I do.
And a couple chairs here. Do you see that?
Yes, I do.
And it looks like there's like a throw rug here. Do you see that?
Yes, I do.
Maybe some sort of looks like box or table there. Do you see that?
Yes, I do.
Do you recall when you were looking in if there was like a couch over here to the right?
I don't recall.
Okay. It's hard to see in this picture, unfortunately. But when you look into this photo here, it's a little bit easier on the real photo. But do you recall seeing what is a sink here?
Yes, I recall.
And then down to the right here, there's like right by the left door, there's kind of like a silver looking thing with kind of like a grated bottom. Kind of looks like a dishwasher. Do you recall seeing that?
Yes, I recall.
Okay. And if this is a sink and this is a dishwasher, would that require plumbing permits?
The connections would, yes.
Okay. And if they got the permits, it'd be fine, correct?
That is correct.
But they just don't have the permits, correct?
Correct.
Okay. So based on what you reviewed, This is supposed to be a workshop, correct?
That is correct.
And in your opinion, is this, I mean, up here, there's like white cabinets. Do you see that?
Yes, I do.
It looks like there's like a paper towel rack over here. In your opinion, does this look like a woodshed?
No, it does not.
Or I'm sorry, a workshop?
No, it does not.
Okay. I don't have any further questions for Officer Jimenez.
Okay, great. Thank you. But do you have a question?
So when do we get the board?
We will, yeah, we'll have a chance to ask of the witnesses.
Okay,
Yes.
just not now.
I just wanted to make sure that they're completely done first.
Okay.
But yeah,
Okay.
definitely. And actually, it's probably best if we'll let them present. We can come back unless there's a time constraint. Officer Jimenez, is there a time constraint for you?
I do have an appointment today at 1, but we should be okay.
Okay, great. Okay, we'll make sure to get our questions in before then. And then, Aaron, do you have any more witnesses that you're going to,
No,
that you're bringing to us?
no, that's it for the city.
Okay, great. And before I move forward, I just wanted to check, does anyone need any kind of recess? And if you do from either side, we certainly can take a few minutes.
A bio break would be
Yeah.
nice.
Bye, bye. Okay, great.
Sure.
All right, let's do this. It is, let me just check the time. Officially, 11:09 is 11:15. Okay, is that enough time? Okay, and
Oh, yeah.
we can give or
Yeah.
take.
Yeah.
It's informal, so, okay, great. So let's go ahead and we're gonna give a recess till about 11:15. Okay, great. Thank you. everyone, all the chairs all the commissioners are back. Wait, Scott,
All the chairs too?
all the chairs too. There you go.
Oh, do we change chairs?
Oh, no, just saying that we're all back.
Oh,
Yeah.
okay. Actually,
I should have gotten.
Okay.
yeah, actually, could we get the
Oh,
extension?
should
cord?
be that, sorry.
Yeah.
No problem. Carry on without me and I'll go get the extension cord.
Thank
Okay.
you.
We-
Okay, great. So what we're gonna do, so we'll go ahead, we'll allow you to present your side as well, and then we can go back. You can present witnesses and we want to just make sure that we get any questions to Officer Jimenez before he has to leave. Okay, does that sound good? And if
Yeah.
any other breaks are needed, just please let me know. Okay, great. Do you need the extension cord before we continue or?
I could use it, yeah, before we continue.
Okay, great. So
Yeah.
We'll take a moment. Okay, sounds good.
We didn't have a sense of how long the meeting would be, so we, yeah,
Sure, it's okay.
otherwise we would have been more.
Oh,
We
right,
charged.
Yeah.
You have PCs, right?
Okay, great. Yeah.
Yes.
Just wait a moment. No worries.
There we go. Anytime.
Yeah.
Use me again.
That's all great. All right, whenever you guys are ready.
All right.
Yeah.
So we,
Actually,
oh,
do you need to maybe go
Yeah.
first? Um. We weren't sure how this was gonna be structured, so one thing that we did do was to put together a sort of a written letter, so to speak. So I'll kick things on off by reading that letter, and then I'll turn it on over to my better half and to go ahead and go through even more granular detail there. And of course, we'll make sure in the process that we're taking the time to ask any questions that we have of Corrado. Okay, I'm gonna start off, again, I'm just gonna be reading this.
oh, sorry, before, just another note is, we did send our, packet, which was posted on the, okay, so I just want to make sure you guys.
We all received
Okay.
it.
Wonderful,
Okay.
thank you.
Yeah, and prior to the meeting.
Perfect, thank you.
Okay, great.
Is this the letter that you're referencing? Is the
A separate from, just, that's our large.
more of
packet.
an executive
Yeah.
summary? of-
Yeah, there you go, yeah.
Very good.
It's only a couple of pages, plus 100, but no worries, I'm a fast reader. This is not a code case. It is a record of broken process, shifting rules, and escalation in search of justification. I'm going to walk you through it because the pattern is the point. Number one, it started with one permit that we had already filed exactly as instructed. This entire ordeal began over a single permit, one that was already filed and in process, done precisely as the Contra Costa County Building Department told us to do. Despite that, a Lafayette building inspector officer and a police officer showed up at our property together on multiple times unannounced with no information about the permit's status. When we asked why they were entering our property without notice over a permit already in the system, their excuse was that they don't have access to each other's CRM system, that the city, or like a database, right? That the city and county can't see one another's records. We followed the county's guidance to the letter. The city sent an inspector and an officer to our door anyway, because they couldn't be bothered to check a database it admits it can't access. So in other words, we complied, they didn't track it, and somehow we're the violators. Number two, hiding behind health and safety. The city invoked the health and safety code and swore to a judge that our property was an immediate danger to life, limb, property, and safety. That phrase is what unlocked the warrant, the armed deputies, and the path to demolition and receivership. Now look at their own timeline. The court signed that warrant on October 24th. The city did not serve it until November 14th, 3 weeks later, the better part of a month. If my family was truly in immediate danger, what responsible agency waits a month to act? And if they could comfortably wait a month, there was no immediate danger, which means the sworn basis for the warrant was false. They claimed an emergency, then sat on it for a month. Their own calendar disproves their own case. Overreaching. Armed sheriff's deputies, 3 vehicles, a warrant that
Mr. Payne,
reached everything.
Can I stop you real quick? Can we swear them in? Sorry. If they're testifying.
Oh, for testify, sure. 1 second. Sure, my apologies. Even though it's an informal hearing, it helps just for,
What does it help for?
in terms of if, just for, so even though it's an evidentiary procedure and they're informal, it's both, the purpose and the city's purpose. If it event goes any further, that we just know that everything is said on the record.
So then, does that include Aaron who spoke? Because I don't recall him actually, being sworn in.
I don't testify. Mine are just arguments, but you're testifying to facts of the case. So unless you're testifying to facts, no, I don't need to be sworn in. So mine are just arguments.
Sarah, do you have any input for the board on this, please?
Yes, I agree with Aaron. If we are giving testimony, like Mr. Payne is providing facts, he's providing testimonial evidence, then he is serving both as a witness and an advocate for himself, in which case swearing in would be appropriate. Whereas with Aaron, we had Officer Jimenez testifying. Aaron was asking questions, but Officer Jimenez was providing those facts and verifying those facts. That's the difference between these two instances here.
Heidi?
Okay.
Yeah, sure.
But if swearing in is, the purpose of it is for everything to go on record, does that mean that even if you're not a witness, or sorry, somebody who's testifying, that attorney's commentary and
Right.
everything that has been spoken is part of the record?
No, that is not accurate. The purpose of swearing is for witnesses only. So Mr. Payne, if you would like to call a witness and ask questions of a witness to verify these facts instead of stating them for yourself in the record, we would then swear in that witness.
Okay. So if I call on Aaron, he would then need to be sworn in.
If you call him as a witness, yes.
Okay. All right, great. So I'm ready.
Learning something new every day.
Yeah,
All right,
lawyers.
let's see, Ms. Page, do you solemnly state that the evidence you shall give in this issue shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Ms. Payne, do you solemnly state that the evidence you shall give in this issue or matter shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you.
Okay, great. Where was I? Hiding. Did I do this part?
Armed police officers.
Yes, at our home.
Hiding, I'll say the city invoked health and safety code. Oh, here?
Right here, I think.
There we go. All right, the overreach. Number 3, overreach. Armed sheriff deputies, 3 vehicles, a warrant that reached everything, the inside of our home, every structure and shed, and even our vehicles. They asked the court for authority to search our cars over a permit dispute. And the inspection they actually conducted was exterior only, yet the order makes the interior findings about the plumbing, electrical, and habitability. You cannot make findings about the inside of a home you inspected from the yard. Number 4, moving the goalposts. The case did not start where it sits today. The original scope was grading and gas line, the illegal dwelling, the hazardous systems, the unfit for human habitation. Every one of those appeared only after the warrant, when the original case wasn't enough. The charges grew as the evidence shrank. That is the opposite of legitimate enforcement. That is a weak case being rescued by changing the rules. Number 5, inventing violations in real time. When pressed, the city will not identify the specific code provisions we supposedly violated because in several instances, there isn't one. They are defining the violation to fit the conduct after the fact. They ordered us to make all toilets working. Our toilets work. A licensed ASHI home inspector confirmed it in writing. They have never withdrawn the finding. They are ordering us to repair what was never broken and calling it law. They refuse to name the code section because they're writing the rules as they go. Number 6, refusing to produce evidence. Despite repeated written requests to the city, Aaron Chandler included, the city's attorney's office has never produced the evidence behind these allegations, not to us, not to anyone. An accusation its own proponent will not substantiate is not an investigation. It is fabrication left to stand. Number 7, abuse of power. On findings it has never proven, the city declared our home unfit for human habitation, transmitted that declaration to our mortgage lenders, and recorded a notice against our title referencing demolition. That is the machinery of government being used to pressure a family towards losing its home. When a government can do this to us on this little evidence, it can do it to anyone in this room. Number 8, conflict of interest. The city outsourced this to a private law firm that bills by the hour. Every escalation, every new allegation, every delay is revenue to them, a built-in incentive to prolong this, not resolve it. And an abatement order is the doorway to receivership, a system where private actors get paid out of family equity. Ask who profits if we lose our home. Number 9, misuse of tax dollars and inflated fees. Lafayette taxpayers are funding an outside law firm to pursue allegations the city cannot document against the family representing itself. On top of that, the fees stacked against us, $36,800 across 9 citations, do not match the city's own published fee schedule. When your charges don't line up with your own rules, that isn't enforcement, it's invention. I'd ask the city to put its fee schedule next to what we were actually billed on the record today. And that's when we'll call Aaron and have them sworn in. Number 10, broken process and broken city-county coordination. The city and the county building departments are not aligned. Officials on both sides have acknowledged it, yet we are the ones held accountable for confusion their own systems create. We are being penalized for navigating a process the city itself admits does not function. And then we should be sure to bring up that email with Jorge on that internal CRM system. Number 11, elected officials who have done nothing. We have filed complaints with our elected representatives. The response has been silence. The people elected to oversee this department have provided no oversight at all, or even incorrect oversight, which my wife will talk about in a moment. That silence is exactly why this board exists. If the elected check has failed, you're the check that remains. Number 12, character assassination and the toll on our family. Uncooperative. neglectful,
Uncooperative,
Junk
aggressive,
and debris. None of it, and this is what Aaron had shared with us earlier, which is why I think he needs to be sworn in. None of it survives the facts. We hauled 12 tons of brush off a untended hillside no one told us to touch to reduce wildfire risk. We eradicated poison oak to protect our children. The city calls that neglect. And even after we formally objected, the unannounced visits kept coming. My wife and 3 young children living with anxiety of not knowing when the government agents would arrive at our door next. Over the past year, we have paid attorneys, licensed soil engineers, a certified home inspector out of our own pocket to disprove accusations the city never substantiated. Number 13, who is being treated this way? We pay roughly $40,000 in property taxes, about 3 times what the typical Lafayette homeowner pays. We're not a family shirking our obligations to the city. We're among its large contributors. This is how we have been treated. So in close, every one of these was a choice the city made. None was forced on it by my family, and not one has been backed by the evidence of this board and entitled to demand. So I'm not asking for a favor. I'm asking you to make the city do what the law already requires, produce the evidence, name the code section, and prove it. Or set these findings aside. They can't because it doesn't exist. Now I will hand the baton on over to my wife, Ann Payne.
Thank you. And I will need to apologize if I've become emotional because this whole process has been very taxing on all of it. It has taken time away from work. We're here. We're not working our jobs because we've had to represent ourselves and essentially convince you guys that we are not hostile, aggressive homeowners that are just letting our property that we've invested in and we've been living in for the past 5 years just go to waste. Why would we do that? We're building a home and a legacy for our children. They're in public schools. We are here. We're part of the community.
We bought a $3 million home.
And the things that the packet that the city has produced, in fact, the packet shows us living in our house, swimming in our pool, hosting a birthday party in our backyard.
You mean Aaron's packet, the city's packet,
The
right?
city's Aaron's packet posted on public record discussing how hostile and aggressive we have been in reaction to police cars with armed police officers coming to our property unannounced, all over technical permits for grading and moving soil to make more parking space so our kids can play basketball on a flat surface. That's really what we started off of. We're not trying to create a dangerous home. The gas line has remained uncapped, not active.
Capped.
So sorry, capped, not connected, not active. We didn't know that we had to have permits for non-active gas lines. What Aaron read, those are documentation at our final inspection when Mr. Chapman came and clarified what that process is. Before that, we have never gotten clarity, and it's been shifting, as Bennett said. Even trying to get the gas line finalized, we called and we said, what do we need? What do we need to make sure that we get this gas line finalized? We actually had we had started the permit back in May 2024. We were issued an active permit in May, I believe, 2025. I don't have the chronology in front of me, but it's
Sorry,
in
is
our
that for the
packet.
gas, just to clarify?
This is for the gas line, which is still not connected. PG&E billing will show that we have no active gas line for that new installation. it was active, and then we still started getting citations and notices from the city, even after we had an active permit. And then they took, when we asked, why are we getting enforced when we have an active permit? And it says we have 365 days from May 2025 to close this. They said, well, if it's enforcement, we can shorten that time period. There's emails that we'll have to dig up to find that. And when we pressed why, we never really got clarity, because our active permit says we have 365 days to close this out. We closed it on February 2026. And even in that process, in the document that Mr. Chandler was walking us through, where with Fred Chapman, and where he told us what we needed, the pothole and the depth. Sorry, gather my thoughts. That process was also broken. It took several calls to clarify what we needed. I called several times to say, what do we need to be able to successfully final this permit? They said, oh, you just need to be there, somebody that's over 18 years old, and you need to have your permit card for the inspector to sign off on. So we called, we made the appointment. And when Mr. Chapman came, he said, oh, what about, well, we need to do the gas pressure test, and we need to be able to see the depth. And luckily, my husband, who's very thorough, had photos of the depth, but he still needed us to dig a pothole. We couldn't do that right on the spot. We were willing to, we had shovels and we started, and he said, no, we'll have to come back. But that is one indication of just the process and the guidance. And they also said, well, if you had a contractor, they would know how to navigate it. We're homeowners, and we don't always have contract. We should know the process. Just because we're not contractors does not mean the process should not be clarified for us, because even if we have contractors, which we do, we've worked with licensed contractors, how do we have the check and balances to make sure that they are also following the process? We wouldn't be able to ask. We wouldn't be informed, because the guidelines and the process has not been clarified. So this is the gas line. I kind of went off on a tangent, but let me just read my.
And let me just add that Aaron Chandler had stated that he used the term future use. Like that was the reason that we were laying the gas line. Actually, I'm a tech guy, so it's a pretty common term, but the term is actually future proof. And when we were in the process of moving towards getting solar, and NEM 2 was going to go away, we went forward very quickly, hastily actually, to buy 44 panels, which based on what the contractor was saying, it was almost commercial level. Now, why would we do that and then turn around and roll out a big old gas line? Well, because even the guy that I was hanging out with at Contra Costa, the field, what was his name again?
Sean Abro.
He was like, yeah, we don't know where the state of California will be in terms of being fully electrified. You did the right thing by rolling out and having accessibility to gas lines down the road, because the last thing that we want to do is, and by the way, the gas lines are like, I don't know, I'm just guessing, but it's like 150 linear feet. And the reason that we did that was because we did not want to redo our motor court, for example, and then come back later on to realize that, oh, you know what, you should have had a gas line in addition to the solar that you have, because for whatever reason, the state of California decides that, you know what, we're going to get rid of NEM 2. We're going to reduce the amount of power that you can sell back to PG&E. If they change the rules on us, then we're stuck with almost $100,000 investment. So that was the reason that was driving the extension for the gas lines. In addition to that, our current gas line for our pool, we have a 40 by 20-foot pool. That was something that we hadn't hooked up, but we were told by friends that gas prices are incredibly high and that we should expect to spend thousands of dollars if we wanted to heat our pool. So we were also waiting to engage or to see products that would actually allow you to use both gas and electric potentially, or heating the pool, or even better, all electric. So, and up until recently, there has not been any heat pumps that would be effective in heating a pool that is roughly 33,000 gallons, which is a good sized pool. So that was some of the thinking that went behind having this gas line rolled out. And it had nothing to do with, oh, we plan on building another like 6,000 square foot house on the other side of the property or whatever these folks are thinking about. So I just want to make sure that that part is clear.
If I could just clarify that I didn't say anything. I just read what the document stated for future use planning. So the document speaks for itself, but I didn't testify.
No, yeah. Let's finish. Are you guys finished with your presentation?
No,
You
we're
want to
not.
go ahead to witness? Okay,
Sorry.
please, Liz.
So let me just, we spoke about the warrant that the city told the judge that there was an immediate danger to life, limb, property, or safety. But if that was true, then why would there have been 3 weeks of not acting when the warrant was signed on October 24th and didn't come out until November 14th? We would not be in a house with our 3 kids in a dangerous property. We put a copy of the warrant in our own packet, which was not provided in the attorney's packet. We asked the city in writing to show us the sworn statement of facts that the warrant was based on. They have never produced it. Here is the part that matters most. Before that warrant, this was a permit. This was regarding permit case related to grading and gas line. The serious accusations, a hidden dwelling unit, dangerous wiring and plumbing, a home unfit to live in, appear nowhere in the city's files until the day that that warrant was carried out. The warrant didn't confirm problems the city had already had on record, and that's where those more dangerous accusations came from, was from the warrant, but we've never been provided proof of how they even obtained the warrant, even though we've asked. You can't find a kitchen or unsafe wiring or unsafe anything in the interior by looking through a window. An outside look can't support these findings. Second, the city's own letters show that this was always about permits and not safety. The city attorney's September letter named only 3 things: grading, construction, and a gas line, and told us the fix was to obtain the required permits within 10 days. That is not how anyone treats a home they truly believe is unsafe. You don't tell a family to go file paperwork if you think that their house is about to collapse. Contradictory within the city statements. In February, the city attorney said no application had ever been submitted for grading. We'd actually started the process for the grading permit in May 2024. After we received a notice to comply from the county. We received 2 notices. And on one of those notices, there was a handwritten note to go to epermit.cc county. So we assumed we start the grading permit through the county because that's what the handwritten note said. And the letterhead was from the county. So nobody had ever told us, oh, the grading actually needs to start with the city website. So that was in, I believe in June 2024 was when we got the notice in May 2024. In June, we put in the permit. There's been delays. So my husband has submitted information. There was one point in time where he couldn't get in touch with the plan checker, and there was some error with being able to load additional information into the county portal. And so I think there had to be a workaround where he ended up emailing information directly to the plan checker, and then they somehow were able to load information into their system. It still has remained open. the unannounced visits from code enforcement and police officers, whenever they came on property, they would say, oh, we're just following up on these permits, but never provided any guidance. And when we asked, what is it in addition that we need to keep moving this along, there was never any information provided that was substantial for us to be able to move it forward. And so we ended that conversation. If there's no progress there, then there was nothing else for us to talk about. And that translated into us trying to keep them off our property and being hostile and uncooperative. The cones that were shown when Mr. Chandler was screen sharing that said no trespassing, we had contractors driving up our private driveway, trying to find our neighbor who was having work done on her property. Happens to be the neighbor who's been complaining on us. We have photos that we would like to show you of that neighbor's property. But the reason why we had put those no trespassing cones was because almost daily at that point in time, they were driving up our driveway trying to find her house. We saw like plumbing equipment, and they said, oh, is this 3440? Naturally, it's the location is a little weird. You have to go around to find her property. And so they thought our driveway was how to get to her property. And we told them, no, this is not her house, but it was almost daily. And so we had to put the cones at the bottom because our kids are up there playing. And we've even had actually.
And this is documented. We actually had some, this people who were on a kind of a robbery spree in Lafayette, where they had the scam where they would go to homes and say that they were doing a job locally and they were there with additional asphalt. And because our driveway is an eighth of a mile long, obviously we were, I guess, good opportunities for them. So they drove on up to our home. We live in a pretty secluded situation. We've got hundreds of trees on our property. So we are pretty secluded. And when they got on up there, there were, I believe, 4 guys in the car. 2 jumped out and began to walk and case around our property. I just happened to be home and not traveling for work, and was on the outside patio and worked from home. She was in the home office. And I stopped them, asked them, hey, why are you here? They said, oh, we sell asphalt. Another guy was going around another way. Anyways, long story short, we sent out an email to our neighbors on La Caminita. They said that they had also saw them. And then another neighbor had said that, yeah, they were found at Wells Fargo cashing checks.
Well, we'll try and stick to it. So you're just trying to clarify that the reasons for the cones being there are different than what's being presented.
Yes.
Just for an interest.
Yeah, sure.
Yes.
Time.
Yes.
Thank
And
you.
so we don't have a gate, and that's the only way we can.
And our other
prevent
neighbors
people.
do.
And our others, yes. So that's what that photo was, that we wanted to stop from contractors from driving up our driveway, which we had a lot of at that point in time. Let's see, so on the grading, back to the grading, is nobody actually ever measured. Everything was based on rough estimates. Mr. Chandler thought or mentioned, oh, we can't seem to figure out what the height is. Soil is not perfect. It's not a perfect line. There's going to be heights where some is 5 feet, in one area is 8 feet, and we were transparent that there's a range. But we provided in our photo, it said approximately, right, 5 to 8 feet in terms of height with depth.
Also, the soil engineer in that letter, he also states approximately. And I think in a moment, I'd like to have Aaron maybe read the letter that he says that he read, because in the letter that was shared with the city, he does not state that the soil, which is bedrock, is moving. Whereas I believe Aaron stated earlier that there was going to be movement expected movement in his earlier testimony.
So the letter from the geotechnical, quantum geotechnical, licensed expert was focused on soil stability, not, measurement. And that's why all of these are approximate. Even when the county came out, it was a visual inspection and said, oh, it looks like it could be over 50 yards, but maybe it's not the volume that's at issue. Maybe it's like the location.
He was fishing.
Did you wanna go ahead and do witnesses? Because then, what we'll do is we'll bring it, after you do your witnesses, we'll bring it back. And we're gonna have the board ask any questions of both you, any witnesses, both sides, and then we can, give a chance for rebuttal and closing before.
Oh, yeah, we
Yeah.
do want to call witnesses.
Okay, great. So
Yeah.
do you wanna, is that good timing to go ahead and do
I
that?
don't know if I don't know how far you've gotten.
One last thing I wanted to note was on the hillside, so the junk vegetation. The citations have some kind of code noted on there. But one cardboard box on our property, on our hillside, how does that define that our entire hillside is full of junk and just not maintained? One cardboard box, one tarp. We had a trash can down there because we are maintaining the hillside. We need somewhere to put, debris. Why is that not allowed when it's completely on our property?
Oh, two things on that. One is that the drop in our backyard, or in this area is about 100 and something feet down, extremely steep enough where we need ropes to go down the hill in many of the areas. And it's roughly about an acre of land. And it is not exposed to anything in terms of a front yard area. And I think that even Aaron will confirm that it being an issue versus being something that you just don't like to see on your neighbor's property through your fence because you decided not to get a wooden fence so that you don't see what's on the other side of someone's property is different. It is completely
It's an
aesthetic
versus code violation.
versus a code violation.
The
And then we had worked with the fire department, who I had shared Aaron's letter with or email with. And he had said that the letter that Aaron shared was extremely conflicting and had provided us with the guidance as he had for the last year. We had been working with the fire department primarily because of insurance motivation, not because of the city. And so we were engaged with them very proactively. And there's the debris that's down there, the old trees that have died and or fallen. Those trees, from their perspective, is supposed to decompose in that area. We have removed any small branches and what have you, in addition to pruning up over 120 trees on that land, on that hillside there, for, again, fire protection there. So really wanted to make sure that we clarify that as well.
Yeah, so I think, well, we were told anything above 6 inches was a county violation and anything below 6 inches was county violation, but I think larger than 6 inches was a municipal code violation. So either way, we're found guilty. When I look at the LMC website, I don't see anything about 6 inches noted on the website. So just conflicting information that we've received, and it's been hard to figure out the path to move forward when things have changed or something new that has been resurfaced or something new was surfaced that we can't figure out what the actual code is. So I think just in general, that's kind of what we wanted to raise.
Thank you.
Yeah. Thank you for hearing us.
Absolutely. Do you want to go ahead and call witnesses and then I can swear anyone in if they haven't been sworn in already?
Why don't we start with Pravda? since he's gotta leave.
Yes,
soon.
I know, yeah, that's right.
What
right.
question do you want to start off with for him specifically?
I guess
today?
the one question that comes to mind, when Mr. Jimenez.
Yeah, he's been sworn in.
Yeah.
He's been sworn in, yes. When you came to our, so you noted that you've met with us several times and, you've come to our property once, March 31st, 2025. That was the first time we met you. And that was the unannounced visit. And we did not have any other interactions since then until the inspection warrant. You told us that you were only going to inspect the exterior. You said you're not gonna inspect the interior. But you said that you took a photo from the outside of the workshop guest cottage because you couldn't get in. And that the door was locked. Can you
provide some clarity on that, especially since, from our perspective, and actually she was there on site, along with other neighbors and friends videotaping you, why you're suggesting that the door was locked when you never checked the door?
and that it couldn't have been that it was locked and that was the reason that prevented you?
And during the inspection, from what I recall, is that the door was shut. I did not attempt to pull on the door handle, but I imagined that it would be secured. But I didn't attempt to go inside.
Okay, but a moment ago, earlier, you had stated that you didn't have time to call to have
A
the locksmith out.
Oh, I had
Why
mentioned
would you?
there wasn't a locksmith present at the time of the inspection.
Right.
So it sounds like it was an assumption that the door was locked and you wouldn't be able to go in to see that there is no kitchen in our property.
Was it your perspective that you could not, since we were actually all standing there videotaping you with our phones, that you couldn't ask us to open the door for you after you had shared with us that you had no intentions of going into any interior?
I didn't ask, so I had no intentions on entering the inside of your cottage.
Okay, so just to be clear, you never touched the handle, you never attempted to walk into the door, and you never asked us while we were standing there and you had the sheriffs behind you to support you to open the door so that you could enter the premises. Is that correct?
That is correct.
You went to there is one side of the property, the back side of our property that, where La Caminita wraps around. That happens to be the entrance for the next door neighbor who has filed some complaints which help to inspire or motivate you guys to come on our property and or come and inspect us. And I've got some photos here. I'm not sure if you'll be able to see them, but I'll make sure that see here, okay. Just trying to see where the camera is.
Camera's
Right here.
But,
Oh, camera's.
where is it?
Just hold it up in front of your
You
face.
hold that in front, yeah.
Oh,
Magical.
that's cool. I'm in tech. So this is a picture of their pool. We had to call Vector, can you see?
There we
This
go.
is a picture of their pool. We had to call Vector Control on out because they were breeding mosquitoes. Their entire property is in shambles. And that's not to dig into other people's stuff, because that's not who we are. However, my point is, I'm trying to understand, as you are trying to call us out for the quality of our property, how is it that the person that you are getting guidance from, who has supposedly called you, who has abandoned cars on her property.
This is, so we have one cardboard box and we've decided thousands of dollars for junk and uninhabitable. And this is just one
That's,
snapshot.
So she's had abandoned cars, she's had pools, she has, this is my favorite one. Where is it?
If I could just jump in here real quick.
No, actually, can you hold for a moment?
Yeah, because I want to make an
Can
objection.
you hold for a moment?
Hold on, I want to
Can you
make
hold
it.
for a moment?
Aaron,
Aaron, can you hold?
it is, they have the floor.
I understand. I want to make an objection here in the hearing, which I mean I could make.
Okay, hold on, Aaron, hold on a second. Sarah?
Aaron
As
allowed to make
our-
objections, so I would
What's
recommend
that?
you, Aaron is allowed to make objections. I would recommend that you hear his objection and then either direct the appellants to continue or provide other direction.
Does he have,
Let me go ahead and ask. Yes, so you're saying that he is allowed to make an objection and that's for both sides. They can make an objection.
Yes, that is true.
And- Okay.
So at this point, it would be appropriate to take a pause, hear Aaron's objection, hear the appellant's response if they have one, and then make a decision as to whether, what direction we're going to go after that.
so I guess my question is regarding an objection. If the appellant has the floor, why can't his objection wait until the appellant is done with them having the floor?
Well, if the objection is relevant to evidence that they're trying to present, which I suspect that it is, it's probably going to ask that the board not consider certain evidence or that the appellants move on from a line of questioning, at which point it would be appropriate for the board to then make a decision. So that's why it's relevant, even though the appellants have the floor, because there could be some parameters Aaron's asking for around what to hear, what to consider, whether to move on from a certain subject.
Okay, we'll move ahead and Aaron, Mr. Chandler will hear your objection.
Well, I want to keep this to relevant evidence. We're talking about the appeal to the citation of 3472 related to law comunita and the notice and order related to law comunita. I understand that they want to show evidence of another property and maybe violations there, but that has nothing to do with evidence to support or not support whether the violations in the citation or the notice and order occurred. So I just kind of want to keep this on track in terms of what's relevant evidence to law comunita and the two issues on appeal versus what's happening with other properties, which has no bearing on, I think, on this hearing. So I would just like to direct that.
I'd like to let you respond.
Yeah, the property that we're showing is the property owner that they themselves, Gerardo, had been in communication with regards to our property. So I believe that this absolutely is relevant.
The property
It
owner
is.
of this property has driven a lot of the escalation on our property, and they would have had to speak and be on site at this person's property. And so we feel it's relevant to show that the escalation and enforcement on our property, you've seen on paper, but there has been, to our knowledge, no similar escalation on this property.
I'm gonna bring it back to the board, and to hear your thoughts on allowing it.
No. Well, no, we just,
If we want to, accept the objection. Yeah.
If y'all don't mind, has a complaint been filed for these things against the neighbor?
Our goal is to suggest that that Gerardo has gone in the process of coming to our property, has seen this,
I
and still continues to treat us unfairly and differently than others. And it's my understanding, though, if there is a situation that is a health and safety issue, that probably should be called out, whether or not another resident calls that out or not.
Unfortunately, your
right?
understanding isn't correct on that.
Okay.
The city's policy is to only respond to complaints of code enforcement.
So wait a minute.
Complaint driven code enforcement. So we have to get a complaint from someone to go after it.
And we.
The abatement is not actually, the abatement order was not sent as a result of a complaint from a resident.
Yeah, that.
So how does that jive?
And one point is, the reason we have wanted to file a complaint, but because of the enforcement that's been on us and the characterization of us being hostile and aggressive, and uncooperative, we didn't want to look like retaliatory neighbors.
Okay.
And that's why.
Commissioner McLean?
I mean.
Yeah.
I guess back to Sarah, can we just say, we note the objection and continue with the hearing?
You have multiple options. You can note the objection and ask the appellants to continue. You can say, appellants, thank you. We understand where you're going with this. Let's please move on. Or you could ask them to completely disregard and move on from the point. So it's at the board's pleasure.
I'm gonna say we accept it, move on.
Yeah.
Good?
Yeah.
Accept the objection?
Yeah, I mean, that we heard it.
Here's Aaron's objection.
We
Here's
use the
the one that-
objection and we understand, we hear the, we understand the direction that you are going in, but we also hear the objection. At this point, we just would like to move on to keep it to as most relevant facts to the case as we can. You guys in agreement?
Yeah.
Is that good? Okay.
Just,
I'm
I
gonna
think I have something to.
abstain because I don't quite understand, but it's two to whatever else, so I'm not gonna.
Yeah, clarification? Clarification is that we hear the objection, we also hear this side, and at this point, the objection has been heard. We stopped to listen to both sides. We understand though the relevance of where this is going. There's nothing you can do from the city side because they're not able to, it isn't, what's the best way to phrase it? There's not much we can do, but we understand where you were going with it. That's our understanding. That's what they wanted us to hear. So we hear it. We also hear the objection and we'd like to move on based on the objection.
Again, our goal isn't to try to have you guys run it over to that property. Our goal is to understand how this all works. And if you're able to send out an abatement order with a list of 8, 10, whatever amount of things of items that you have never seen, experienced, or anything else, and the abatement order then is dependent, based on what you just shared, on a neighbor being the one that calls it out. I'm trying to put it all together to understand how that process works. How is it that we received an abatement order if no resident, no neighbor called?
Mr. Payne, I think appropriately, that was a question to ask Mr. Jimenez, perhaps, if there has been a complaint issued and then what the basis of issuing the abatement letter was, just to keep things moving. I apologize for the interruption.
Yeah, sure. Do you mind answering that question?
The question being that if there was a complaint filed?
Well, sure, we can start there.
Yes, there was a complaint that was filed.
For the interior of the property.
Pertaining to what was reported as a second house.
I'm sorry, I'm referring to the abatement.
I'm afraid I don't understand your question.
Let's, do you want to bring up the abatement? Can we share our screen? I think the abatement is actually in the file as well, but it's from BBK. So maybe you guys could pull up the abatement.
So is a question as how did we get to the abatement portion of the case?
Well, first off, did a resident call? How is it that you came up with, say, for example, the one of the call outs you had was the plumbing? Our plumbing, our toilets not being able to flush. How is it that you came to that conclusion? If you were never inside the interior of the house, of the structure.
So regarding the specific verbiage that was on that abatement letter, I had no control over what was on that letter. That was just what was sent through our attorney's office.
Sent by whom?
Through our attorney's office.
I'm sorry, but
Through BBK.
I'm sorry. So you said that you're responsible for the inspections, the permits, that part of the building component. And you're saying that someone within the Lafayette City Building Department, not yourself, sent the components of that letter to Aaron Chandler to compose the abatement order. Is that what you're saying?
So the abatement order was based off of the notices and the citations that we sent. So after citations have been sent, we then can consult with our city attorney to discuss the appropriate next steps. The next steps in this case being the abatement that you received.
Okay, could you share with us what citations tied back to the abatement? Because we are not aware of any citations that tie back to the components of the abatement.
One such citation is a citation that we're currently appealing today.
Which is?
December one?
Yeah.
Yeah, the December citation.
I'm sorry, and what was in that citation that's reflected in the abatement order?
This one.
The first item on the abatement order says substandard building. It says completely unfit for human habitation. The property is poorly kept, unsightly in the community, an attractive nuisance, unsanitary and unhealthy for human occupancy. Poses substantial danger to health and safety. So what part of citation 342 shows that our property is uninhabitable?
So again, I'd like to clarify that that was not my verbiage. I did not put that in the letter. That was coming from our attorney's office.
Can we swear Aaron in, please?
Well, are you?
Because we'd like to ask Aaron who.
Officer, and then
Okay,
let's do
all right, great.
Let's.
So it sounds like the 8 items in the order to abate is not from you, driven from your citation.
So they are, what is referenced in the abatement is what is referenced in our administrative citation. So for example, when you bring up the habitability concern, one of the code sections, and I'm trying to find it, but it is under the California Health and Safety Code for improper occupancy. So the improper occupancy code just specifically states that it is an area that is not meant for that occupation. For example, if somebody was habiting a garage that had no, or that was not approved, or had fixtures or what have you, and there was no permit history for a garage conversion and somebody was living in there, we would deem that to be uninhabitable. So meaning that nobody is allowed to live in there because it wasn't permitted for occupancy.
Okay, yet the order to abate is on our entire property and sent to the lender. And our lender thinks that our entire property is uninhabitable.
Can you tell us about, in the order abatement, I think that there's something about plumbing, right? Or toilets?
Yeah, so
Can you walk us through that and the connection between your?
yeah, because item 7 on the order to abate says plumbing fixtures and facilities must be properly maintained. Repair the plumbing fixtures to meet building and plumbing code standards, including repairing all toilets to working condition.
Can you walk us through that?
So that would possibly in reference to what was listed on the citation under, again, the California Health and Safety Code for plumbing. So in the notice, it is just to bring all unpermitted plumbing up to code. So again, that could just be a standard template from the attorney's office. I'm not sure, but I didn't call out any toilets specifically in my citations.
Okay, because it's on the order to.
It's on the order to abate that was sent to our mortgage company. So it's actually pretty serious.
Can I just try to explain there?
Can you share with us, Gerardo, like what role you played in the information that is here? And can you confirm that you actually read the abatement order when it was prior to it being shared with us?
Yes, I was sent the copy of the abatement to review and send out.
Is there any reason why you didn't correct or provide additional clarity for the abatement order to whomever sent it to you before it was sent to us, since it was sent to you before it was sent to us? And you're the leading officer.
Since I was not able to inspect the interior, I decided that the verbiage was appropriate in the event that maybe the toilets didn't work.
In the event that maybe the toilets didn't work? Is that what you said?
That is correct, yes.
Okay, so it's based on assumptions that our toilets didn't work. And that's why you approved that language. Or any of our plumbing, I guess. Do we want?
Do you have any other
switch?
questions for, yeah?
Yeah, let's switch.
I think, yeah, thank you.
You know, I know in an interest of time, I'm gonna take a quick pause, and if there are any questions from the board, for Officer Jimenez, we should ask now before it's due to time for staff. But we'll start with the board.
No. Yeah, I do. No, that's not the one I want. There we go. So we're looking at the administrative citation 342. It's the one in
December 12th.
And so can you point out on the citation the plumbing code action?
That would be, I'm not sure if the citation is in 1 page or 2 pages on yours, but if it's on 1 page, it's on the back of the page. We're looking at CHSC 17920.3. And that is for E as in echo for hazardous plumbing.
And that you're saying that pertains to the gas line?
No, that would be pertaining to the plumbing.
Okay. So I guess I didn't ask the question correctly. Pertaining to the gas line, the unpermitted gas line, can you point out the code section on that citation 342?
That would be on the first page. So that would be California Health and Safety Code 17920.3 F as in Foxtrot. All mechanical equipment.
I was under the impression that gas lines fall under plumbing.
For the board's convenience, I would direct you to the citation directly above. I'm looking at 3-304. There appears to be a reference to plumbing.
Yeah. So so here's why I'm asking the question. 3-304 is building code, not plumbing code.
I apologize. I apologize. I misspoke. That is a gas line that was stuck on plumbing. It does say here to the installation of the gas line and unpermitted grading on the property.
The, 3rd one, yeah, so it's the 3-304, it's the second one. It says the installation of the gas line and the unpermitted grading of on the property.
Okay, so gas line is, yeah, I mean, 3-304 is building code, does not apply to plumbing. If you go back to the first notice of violation back in May of 2024, there was an NOV for gas line 3-306 plumbing. And so I guess my question is coming from, it looks like there's an inconsistency of dumping plumbing, a plumbing code issue under 3-304. And so is there any additional 3-306 notices to the appellant plumbing code regarding the unpermitted gas line?
If I could just turn your attention again to the California Health and Safety Code referencing 17920.3E as an echo for hazardous plumbing.
Okay.
I just jump into
Yeah.
it's related to that. I just have a question. So my understanding from this from this citation, this is all in terms of the plumbing, it's in reference to the unpermitted second ADU. This has nothing to do with their house, house proper, correct? Like the main living, this has nothing to do with that. Because this is saying, this is for the CHSC, it is including but not limited to all unpermitted plumbing fixtures and connections related to the unpermitted second unit. So you're not talking about anything in the main structure of the house, is that correct?
If I may again turn your attention to that same code section, the first sentence, obtain permits for all hazardous plumbing on the property, including but not limited to.
To the second unit, but when you wrote it, was it for, I mean, were you looking at the whole house? That's my question. I think I'm confused by that.
Yes,
Because
it is addressing any unpermitted construction related to plumbing, including but not limited to any plumbing additions that may have been related to the potential ADU or the second unit.
Okay, go ahead, Bob.
So going to the section that you're referring to, 17-920.3. Any building or portion thereof, regardless of the zoning designation, or approved uses of the building, including any dwelling unit. So 17-920.3 appears to apply to buildings, not underground gas lines. So again, I'm going to question the applicability of 17-920- or .3E to underground gas line.
I'm gonna say that's more of a legal question than his, but structures can include walls, pipes, as defined under the health and safety code. It doesn't have to be a shed or a house, but I think that's more of a legal question for Gerardo. But it includes pipes, walls, anything that can be constructed for the health and safety code.
So a building is typically something with like a roof and enclosed walls. I mean, that's kind of what a building is.
Yeah,
I think you'd be really hard pressed to say that a gas line in a trench is in a building. And I think that's more of an interpretation of the code rather than a legal issue.
Well, under the building code, they have a definition for building and they have a definition for a structure. And so they are different, but one can also mean the same. A structure is a building, but a building doesn't necessarily mean it's a structure. So
And what's the relevance of what you just said to an underground gas line?
Well, the grading is also something that can be defined under the building code. Any construction, digging, so there's no structure there, there's no building there, it's just, digging or grading, and it would be controlled under the California Building Code. So, I think there's like a few definitions that are applicable to the building code or the building standards code. So under the building standards code, there's the plumbing, the electrical. Electrical is not a structure, but it's under the building standards code.
Oh, yeah.
Yeah, okay, fine. Yeah, you go with that.
Sorry, I guess I have an objection to that, because there's different, I'm looking at the citation and December 12th, and these were all written before the ADU items were added. So the first code sections weren't even, I think those were raised before the inspection warrant happened. And after the inspection warrant was when all of the ADU allegations came about. This hazardous mechanical, which is the third item on the citation, it sounds like you guys, Mr. Chandler, Mr. Jimenez, were referring to the gas line, but that is not related to the gas line. The gas line is called out in the second item of the citation, which I think Mr. McLean said this says building, but that's really a plumbing. So you can see why we have been confused about what exactly is the violation. And at the same time, we've been trying to put together or move forward with this gas line permit and grading permit. We do not know what this mechanical equipment citation is about.
Okay, we'll
So,
pull back to,
Sorry.
I know it's okay,
So
are we good to note that objection to this? Okay, we're still gonna move on.
noted,
Keep.
duly noted.
Thank you.
So going back to hazardous mechanical 17920.3F. So here's where I'm coming from. I used to build homes, and if I had an inspector come in and say, you didn't pass, and then just leave, I got nothing to go on. It's there's 850 things that could be wrong. And so that's why you get a note or a write-up or something like that. So referring to the hazardous mechanical, what specifically did you observe and what notice was given to the appellant of that specific thing that you saw?
So I was going based off of the notice to comply sent from the county regarding grading and the unpermitted gas line. Using the mechanical code was an oversight on my behalf, so you're correct. I used the incorrect code section there.
And then I'm going to follow up, same question on hazardous electrical and hazardous plumbing.
So regarding the code sections for hazardous electrical and hazardous plumbing, those were looking at the dates, so amended in October 14th. So after the warrant was served is when they were included. So those two code sections are mostly pertaining to any unpermitted construction regarding the cottage or the second unit.
So what I'm hearing is that you did not identify anything specific and you did not give any specific notice to the appellant of your findings.
So in the citations, it does say to obtain permits for any unpermitted construction, including but not limited to. So during the inspection, and as our attorney had pointed out, there were some electrical fixtures visible from the exterior that appeared to have been installed after the fact. Regarding the plumbing additions, it does appear that there is a kitchen inside the cottage that may have also been installed after the fact, that may have included plumbing lines.
So using the electrical as an example, just because something is installed after the fact or bootleg, does that automatically make it hazardous?
We don't know how it's installed, so it could be, yes.
And I
Yeah,
would,
so unspecified.
well,
I
I
know.
would say that calls for like a legal conclusion because per the code, if it's unpermitted, it's deemed hazardous. So that's a kind of a legal analysis or legal conclusion for Mr. Jimenez to discuss, but
If you could produce that code that you're talking about, that would be helpful.
sure, I could send it to everybody.
Next question, if I can find my notes. So code section 3708 is the whole thing's not really in here in the notes. What's the violation to section 3708?
I mean, that's right.
Yeah.
Yeah.
And so here's where I'm coming with that. So 3708 now it says 716-1416B was adopted. And 716-41416B says land use. The county building official shall not issue a grading permit for work that will not comply with all provisions of Title 8, or which in this case, Title 6, because that was the amendment, and any conditions imposed by the planning agency or approval of the use. So that section appears to apply to the county building official, not the appellant. And if I were to use Matt as the example of the county, as the person issuing permits, that section appears to say, hey, Matt, you can't issue a permit that doesn't apply with all the conditions of Title 6 of the Lafayette Municipal Code. You owe me $1,000. I don't follow that. So my question is, how does this section 3-708 apply to the appellant?
If I may, let me just find that code for reference.
I don't, can you say that question again? I don't really understand it.
So So 3-708, this is in our handy dandy field board packet, yes. 3-708, County Ordinance Code 716-4.1416B. That same section that was adopted by reference by section whatever and is amended by deleting the reference to Title 8 and substituting the reference to Title 6 of the Lafayette Municipal Code. So just based on that, what's an appellant supposed to do with that, for one? And then if you go further and actually look at what is now the amended section 716-4.1416B, all it says is the county building official shall not issue a grading permit for work that will not comply with all provisions of Title VI of the Lafayette Municipal Code, and any conditions imposed by the planning agency on approval of the use. So the reference section appears to apply to the county building official, not the appellants or any applicant for that matter. And so
Well, go ahead. I'm sorry. I didn't mean to interrupt.
I'm just trying to get clarification as to why something applying to why would an appellant be dinged for something that applies to the county building official and their responsibilities and duties?
Well, no, the reference is the county building official or their designee will not issue a permit if they don't comply with all county and local rules. So it's their authority to deny a permit unless they've obtained all the required permits in order to make, whatever construction that they're going to do.
The county official needs to get all the appropriate information before they can issue a permit. Correct? Okay. Again, I didn't hear any discussion reference to applicants or the appellants.
It wouldn't, because this is the building official's authority.
That just answered my question. Thank you.
Okay.
Actually, I have a question related to that,
Go
to
for it.
jump in. It says 3-708, when we're looking at, again, at the citation 342. You were referencing, I understood where you were going with that, but in here, it's just talking about the grading. Did you see that? So it's a question, just an aside, is that the same thing that you were discussing? I see what you're saying about this, but just I want clarification. Is this what you're referencing in the citation? 3-708, is that an incorrect?
I think it's something that just doesn't apply to this case.
Right, this is talking about a notice to comply, stating the
Right.
grading. This is just
Yeah.
about the grading.
Because I think the section, I think the whole 700 applies to grading. See, that's 3-701 is grading, 3-708 is grading. So I think the
Right.
whole 3-701 is grading.
But you were referencing, and you're referencing this part of it.
But I'm saying this part
Doesn't, okay,
doesn't
got it.
apply because it's going to
Okay,
the building official.
okay,
not-
thanks for
not the-
clarifying.
part does.
Okay, all right, good.
That part, I still think that's.
Curious.
Got it.
So, okay, question for Sarah. In terms of like procedures. I'm just trying to get the I blanking on the word. So the process goes, what is it? Notice, warning, notice, citation. And so does every violation have to go through that process? And like I'm asking is, for example, the junk one shows up for the first time on administrative citation 320, but there was never a warning, a warning notice or notice of violation specific to that item. So is that like an error? Should there have been Or can you just, oh, hey, here's a citation. I'm just gonna start dropping stuff on that citation without having given the duly, the due process of the warning notice violation before that.
Hmm. So it is definitely common practice to do a warning notice and citation. I do believe these citations have, and I believe Officer Jimenez testified to this as well. The deadline provided for either compliance or payment of the fine. I believe that provides discretion to the city where if the person cited provides compliance or otherwise challenges, then the fine can be waived. I don't know if Aaron has a little bit more to add to that from the code side, specific to
I mean, it's
procedures.
Yeah, I mean,
no-
it's procedure code, and I don't think I should hear what he has to say. You're here for the board.
Mhm.
Well,
I don't think it's appropriate for you to reference him for advice. He's on the other side.
Well, I can make a legal argument in terms of our position in issuing the citation.
Do you want to hear his position? Otherwise, I'll take 5 minutes. I'll read through the Lafayette Code in more detail. And I can come back with a really concrete answer for you.
Sure. I
Okay.
think that'd be meaningful.
And just based on time, let's keep going with Officer.
Yeah.
Jimenez. Okay.
I'll take a break for the moment because I need to just
All right.
review.
Great, okay, I'll ask a question. I wanted to hear more about when you visited, and the citation, it was referenced, let's see, 8-2105A58 is about the general property junk. Because there seems to be discrepancy in the way it was characterized from your standpoint versus what the Paynes are saying in terms of a cardboard box, a tarp, and a trash can. Can you clarify a little bit more what you saw, since we were not there?
It was, as they described, in my opinion, it was relatively minor, but it was still a complaint that we received, and it's still in violation of our Muni code. It is trash and debris that is visible from an adjoining property. And again, it was a complaint that we received.
Is that common for that level of junk to even reference that? I understand that it was a complaint, but just in a neighborhood, I think on any given day, that could definitely be seen in someone's property. Is it that it was the complaint? It was there all the time, never removed?
Yeah, so it's part of the complaint was that it had been down the hillside for some time, and that is what warranted a call to code enforcement to address the issue.
Do you have any questions? No, still, okay. Okay, good. Yes.
There seems to be a discrepancy on the grading volume. And so, what's your estimate of the grading volume and how did you figure that out?
Again, my reference in the notice of violation and the following citations were based off of the county's notice to comply.
Okay. Did the county provide any calculations or basis on their estimate? They ever provide anything?
The only thing they provided again was the notice to comply.
Fair enough.
Can I interject back in again, wrap back to your question?
Oh, there you are.
Okay,
Yeah.
so a good opportunity to pause. So I'm looking at Lafayette Code section. This is chapter 1-9 administrative citations. It lays out the procedures both for issuing notices of violation, warnings, citations, and then it also provides administrative penalties and our appeal procedures. So looking specifically at section 1-903, this lays out when a warning notice of violation and time to correct is issued. These are permissible, not mandatory. So the language is, if a code enforcement officer determines that a violation has occurred, and I am summarizing a little bit here, so please open up the code section. It's available online if you want to take a look at the exact language. But the officer may issue a warning notice to the owner, which would contain address of the location, description of the violation, and applicable sections of the Muni code, requirements for abatement, date of correction, and consequences. Those are in the warnings. and then the violation is not abated within the time limit in the specific warning notice, the officer may then issue a written notice of violation to the owner. Again, similar requirements, date that the violation was observed, address of location, description of violation and applicable sections, requirements for abatement, consequences for not abating, and then name and signature of the code enforcement officer and date of issuance. Moving down to admin citation at 1-904. When the code enforcement officer determines that a violation of this Muni code for which a notice of violation was issued was not corrected by the correction date, then the officer may issue an administrative citation. And again, it goes through all of the very same requirements. So it does look like there is a notice of operations here, or a timeline of operations here, like you were saying, where we go from warning notice to notice of violation to admin citation. An admin citation cannot be issued unless a notice of violation has been issued.
Thank you.
Any other questions for the officer? I know just for time.
Yeah.
Do you have anything
I
else?
think I'm good.
Okay, great. Thank you. We're all good. Any further questions that we have for the officer? Okay, great. Thank you so much for your time, and we appreciate it. I think we'll rest right now for you, officer, to get you to your meeting on time. We'll break
Yeah,
before
thank you,
then.
Gerardo.
Yes.
Of course, thank you all.
Thank you, Gerardo. Have a good one.
You too. Thank you.
And before we move over, I know you want to do another witnesses. I respect for time. I'm going to say two things. One, in terms of a recess, and the other is, do we need, let's talk and with city staff in terms of continuing to go on, or do we need to recess and continue a different time?
I personally only had one single question for Aaron before he gets sworn in.
Okay.
Yeah, I'd certainly like to be heard on that because I don't have any personal knowledge about anything that would relate to evidence substantiating the citation or the notice and order.
Okay.
And I see a hand raised.
Yeah, I do see. Yeah, we will get to other,
Okay.
to public to other witnesses and public comment for sure. That's why I'm saying if we want to do this, we'll do this, and then if anybody needs a break, a quick, even a bio break.
They're gonna want to eat.
Right, I know, that's.
Yeah.
Okay, let's do that. All right, why don't you do this? Swear again then. Okay, all right. Okay, Mr. Chandler, do you solemnly?
What I'm saying is I'm not going to testify. I have no personal knowledge of the facts of this particular case. I'm just the attorney for the city. So I don't have, I don't think I have it.
So Sarah, just a question to you, Sarah, we can still ask questions of the attorney, is that correct?
Well, he has to have knowledge of the subject matter. So if you're going to ask about certain facts about the property, about the city's process, those were questions for Officer Jimenez. So I'm not sure. Aaron hasn't offered any testimony. He hasn't taken the stand. He's just been asking questions of city staff. So I'm a little bit confused, I guess, a little bit perplexed. That's not to say you can't call an attorney as a witness, but he hasn't been given any testimony. He hasn't testified to any facts.
Can I put an objection forward then?
Yeah. Hold on,
Well,
Bob,
There has to be a question.
Can I ask what the objection is?
If I'm like asking a question like previously and Aaron said, oh yeah, I can get you that code set, all by definition, something not built to code is a hazard. That is like not advising the city. That seems to be providing some sort of testimony at that point. Yes?
I disagree.
Because
if you're asking him to Google something and pull it up for you as an attorney for this city, he can absolutely do that. That's within the bounds of the hearing. You can absolutely ask the city to provide more evidence or explanation. You also asked that question of Officer Jimenez, who is not an attorney. So, I mean, I think we were trying to support the board in that moment. I wouldn't consider that to be witness testimony.
Okay.
Okay.
What's the question you want to ask?
Yeah, let's hear the
Question.
question. I'll just, yeah,
So-
Let's hear, can we hear the question, then maybe you see what we can do?
yeah.
Yeah, I actually had two questions. One was that Officer Jimenez said that he did not write the abatement order. He said that the city attorney did.
Correct.
So if Aaron is acting on behalf of the city attorney, I wanted to get some additional information with regards to that, because Officer Jimenez seemed to not have a lot of details or on the abatement
For
order.
this legal abatement.
For the
order.
abatement.
Yeah.
Or- That's correct. And then my second question was really around the understanding, we're trying to understand why we're being penalized for calling the structure a cottage. Like, I'm trying to understand, like, if a realtor represents the structure as a cottage, is the realtor then fined or sued because they called the structure that was built 30 years ago by a different name than what the name of the structure was in the permit 30 years ago?
So you're not being
Does that make sense?
penalized. You're not being penalized.
So those are my two questions.
Well, again, that I don't have knowledge of those facts. I can't add anything to that. I don't, my testimony wouldn't support evidence to say that yes, there was a violation, or no, there wasn't a violation. So,
Let me ask again, because we actually have email communication with you. Do we not have the right to call what is called a workshop in the permit that was done decades ago? Can we not call it could we call it a gym? Could we call it a kids band room? Could we call it
Mr. Bennett,
you know,
you can,
I would appreciate it if you didn't
well,
interrupt me every time I spoke, but
well, I'm not,
But go
I'm
ahead.
not going to testify, and I want to answer your question as fastly as possible so we can get this going. You can call it whatever you want. The
Okay.
violations that the city is looking at is what have you done to the property that needs permits? That's the allegations here. So is there unpermitted electrical? Is there unpermitted plumbing? Has there been an unpermitted structural change? That's all. And you can call it
The
a gym,
reason,
or you can call it a shed. You can call it anything you want. That doesn't change what the citation and the notice and order are saying.
but
Actually,
the reason why Bennett is raising this is because there's an email chain from you saying that it is not a big leap to assume that this is an ADU when the captions in the photos call it a cottage.
Correct, but that's an argument. That's not a fact of anything. So, and I
So
don't
isn't
have,
it kind of,
I don't have any
Sorry.
expertise. I've never been to the property. I've never seen the property. I'm just making legal arguments or assisting Gerardo in testifying. So again. that-
okay. And then our second question was around the abatement order and your level of participation in writing that.
Sure.
Can you share with us what your level of participation was in writing that order?
I drafted it.
Okay.
So I got a question for you, Aaron, on that. So
Sure.
I thought I heard something like everything in this repair or abate order references back to the administrative citations.
Well, my comment or my argument in the beginning was most of this relates back to the notice of citation, except for the trash, debris, and overgrown vegetation.
Okay, so then I guess my question then for Sarah is looking at this order to repair or abate, and let's look at the paragraph number 7, substandard building. And it references California Plumbing Code 422.1. And I don't believe that section was ever referenced in any of the administrative citations and not the one that we're talking about right now. So
Correct.
what is the board supposed to do with that if, you know?
Well-
I'm hearing that this thing's only supposed to apply to administrative citations, and there's things in here that are not.
Well, the city is entitled to provide administrative citations for violations to the California Building Code. That's like our big kind of umbrella term for the mechanical code, the electrical code, the plumbing code, the green buildings code. So the city is entitled to cite for those kinds of violations under its police powers. As far as what can the board do, the board has the authority to, uphold, modify, cancel in whole or in part, and that should be based on the substantial evidence standard. So we're looking at if the city has presented substantial evidence to uphold its requests, to uphold its actions. If the board finds that one or more or all of the violations do not meet that standard, then the board can take appropriate action to cancel or modify, vice versa at the board's pleasure.
And we, just,
Was,
go ahead. Keep going.
so, we just agreed that you can't do administrative citation without a prior notice of violation. And I'm being told that this order emanates from prior citations. Yet there was no notice of violation for plumbing code 422.1. So, is your opinion that parts of this order are, would you say they're not valid because they haven't been given the due process?
I think that's a question for the board. The facts are before you. Was this violation properly noticed in accordance with the municipal code? If you find that it was not, and you don't believe there's substantial evidence to support that, then the board can take appropriate action according to the municipal code. I know it might seem like I'm ping-ponging back with you, but I'm not trying to be unhelpful. You are the decision makers here. So I'm stating out the parameters under which you're entitled to make a decision. I'm not going to tell you how to make that or what decision to make.
Correct.
Okay, and I have a question because we do need to go on to the other witnesses, but my question is in this abatement order, it's number 3 for the structure unfit for human occupancy, the unpermitted construction. This is the question I also had for the officer. This is where I'm confused. I feel that all of the writing is about the unpermitted, perhaps the garage conversion that has walls. That's what everything is referencing. But my understanding from the Paynes is that and that officer said it's for the entire structure. And that's where I'm confused at that. That feels like a sticking point that sounds like it then got escalated to their mortgage company. And I'm unclear how we go from looking at on-site at this garage workshop to the entire house.
Well,
Can you explain that? I don't understand.
Sure, yeah.
Thank
So when you look at the health and safety code, this notice in order to abate is required to be sent to all interested parties. And it doesn't relate to any particular structure per se. It relates to the address and to the APN number. So it applies to the entire property. And so by law, when we issue this notice, we have to notify all interested parties, any lien holders that are on the property, any mortgage that have a mortgage on the property, anybody who has a recorded interest in the property has to be notified. And it's structured this way in terms of it applies to the entire property. It just doesn't apply to just one single, outside parcel. So, if you had that, it would just be too difficult to say it applies to this property, but only this portion on the right-hand side and identifying the pipe. And so it just applies to the entire property.
But this letter does reference, it does try to narrow it down in its wording, is that?
Yeah, correct. That's right, yeah.
That's its intention,
Yeah.
correct?
Yeah,
Okay,
we try,
that's-
yes, exactly. We try to say this is related to the the ADU or the structure, not the main residence or the pipe. So it's a little, even though it applies to the entire property, we do try to make it clear that it only applies to, what the structure is in terms of what we believe is unpermitted.
Okay, thank you for the clarification.
Can we ask for the code for where Aaron states that it's mandatory or some code to send it to mortgage companies and to all the lien holders? Did we get that code?
Sure, it's in the
Okay.
notice. It's in the notice.
Okay.
17980.6 of the Health and Safety Code.
And it's mandatory. It's not something that you cannot do. You have to do it.
17 minutes.
That's what you're saying, Aaron?
Yes.
You don't have an opportunity to not do it.
Correct. We have to notify all parties with an interest in the legal interest in the property. So.
Okay, and that includes our
Lenders. Yeah,
does that include our tenants of our rental property as well that you were sending certified mail to?
Anybody who has an interest in the property or anybody that has a possessory right in the property.
And how do our tenants have that?
Well,
Are you
they're-
referencing the Ardmore address in Oakland?
yes.
Probably because it's an answer for Aaron, but I'll surmise that to cover bases, they send it to all known addresses.
Correct.
And that may well have popped up. I mean, they're not sending it to your tenants, it's sending it because your name's still on that address somewhere. And they're just trying to make sure that you receive this no matter where you are.
Any address that comes up that's a potential interested party, whether they have a legal recorded interest or they have a possessory interest, we're required to notify everybody. And that's included in posting it on the property. And that is more so for the tenants, the posting versus, mailing it out. But we have a legal obligation to notify everybody.
Yeah, you actually did not post at our rental property,
You can ask.
but I
Joe.
understand. Thank you.
I just want to ask a procedural question. Can I just, if you're in the audience and you have a public comment, or let's start with you, let me apologize. Do you have witnesses that you still want to address?
No, but I have one last question.
Okay, let me just, that's great. Let me go ahead with that question that I was asking the audience. If you are in the audience, please raise your hand just so I can see how many public comments we will have. I'll give you 1 minute. Okay, right now I'm just seeing one hand raised. Please raise your hand on the Zoom if you have a public comment, and I believe there'll be one. Am I correct? You have a public comment?
Yes, I'm being voluntold.
Okay. So there'll be two public questions. Okay, you can, that sounds great. All right, so why don't we go ahead? Does anyone need a quick break? Does everyone do, okay, yeah, okay, why don't we take, it is, okay.
I told you the coffee was good.
It's 5. We're gonna take about a 5-minute break. What I'd like to do is come back. We will address the question that you have. Then I'd like to go ahead and take the public comments. And then we will bring it to the board for discussion. And if there's we'll say if there's any closing remarks as well. So we'll do that when we get back. Okay.
Just because we have our kids here.
Yeah.
How long do you think that might be?
Um,
They haven't eaten since breakfast.
yeah, exactly.
No,
Well,
nobody
that's why I was asking a procedural question in terms of, yeah, exactly. Do we have a time frame that the city has to extend, do we know by, in terms of meetings? I know only from other boards.
We don't have, unlike a city council meeting
Right.
where you have to vote on extending it
Yeah.
past midnight. You don't have that here. If this goes that long,
Yeah.
that's bad. So we don't have to vote to extend it, but you can vote to take an adjournment of some period of time so that people can eat, pee, things like that. I would suggest if this is gonna be wrapped up in the next 20-30 minutes, that let's soldier on after a bathroom break or a bio break, as you.
Yeah.
I like that term. Rather than
Yeah.
giving everybody an hour to go eat and then starting over, that
Yeah.
seems.
We just wanted to know if we needed to be here for deliberations, could we leave with our kids, or do we need to be here?
I mean, there might be questions,
There might
right?
be questions. So why don't we do this? Let's make it that if it is,
Good.
are we good with if it, we'll take a 5 minute break now, and
Yeah.
if it goes much past, let's check in by 1:45 and see, because I
Okay.
do understand that
Yeah.
people have other things to do and eat. Okay.
I'll go see if we have some snacks.
Okay, great. So let's just,
Yeah.
let's adjourn for, roughly about, 5 minutes or so. So let's certainly be back no later than 1. One is back, so we'll call back to order. Perfect, 1:15. And I would like to, let's take a moment and go to public comment, just because they've been waiting and they may have some other things to do. So let's go ahead and we're gonna start with, let's do that. Let's do the public comment online and then we'll move to the room. Okay, great.
So-
Yeah, go ahead. Thank you.
First, we have Joanne Munoz, who is now allowed to talk.
Great, and our typically in meetings, we give 3 minutes for public comment. So if you could do that, I would greatly appreciate it. Just keep moving this along.
Got it.
Okay, welcome. Can you hear us okay?
Hi, thank you. Yeah, I can hear you. Can you hear me fine?
Yes, great, thank you.
Okay, hi, my name's Joanne Munoz, and I am Friends of the Pains. I am also a pediatric ICU nurse at Stanford and have always upheld the fact that I have a legal duty as a mandatory reporter to protect the safety and health of any individuals who might be in harm. I have been to the Pains residence on multiple occasions. I have known them since they have owned the property. My observations are limited to the fact that I can only speak to when I am there, but at the same time, I will say that I was present for the search warrant. From my understanding, when they came to appear and assess the property, the gas line was confirmed that it is capped. As far as the grading measures go, they did not pull out any form of measurement in order to actually give an accurate measurement. There was no tape measure that was pulled out. There was no real even discussion regarding the grading. As far as what you guys are speaking of with the garage and the carport, my understanding that it is not an ADU. Bennett and Ann have both taken me through the entire property when they first got it. And then I have been on that property multiple times and they have shown me progress of things that they have done. At that time, I can confirm with you that in that section that is to the right of the basketball hoop, there is no plumbing. There is no toilet. There is no kitchen. And I also know that because that area is not in use from the Pains, when my son and my daughter go and visit there, that part of the property is not accessible to them because it is still on that side of the property that has not been really worked on, and there's really no reason for them to go in there. The code enforcement officer did not ask for the structure to be opened. In contrary, he was stating that they were only there to inspect the exterior of the property. Not once did they try and open the door. Not once did they ask the Pains to open the door. And not once did they go into the back to look through any of the property on the exterior, like on the main residence portion. I do kind of am curious if it's common for an inspector to be accompanied by 3 or more police officers, in addition to wearing a bulletproof or resistant vest. It seemed a little bit on the aggressive side from that standpoint. However, when they are asking the Pains if they would be able to show them any part of the property, they were very respectful, very willing.
Apologize, but just your time is up. Could you just give a last-minute wrap-up?
Yep. So what I'm just trying to say is that every interaction that I have had with the Pains and their home has been safe. They have flushing water. They have water that they can use in their kitchen. I had direct conversations with them regarding solar and how they were getting it permitted immediately. And they have always complied and been a productive member of the Lafayette community. And I have nothing negative to say about this family. As you can see, if you look at their 3 children who are unbelievably behaved and unbelievably well adjusted. it
Thank
can
you
just
so-
kind of
yeah.
attest to the fact that they are a very
Thank you.
important piece of this community.
Thank you so much for your comments. Okay, great. If we can move on to the next speaker.
All right, so the next one is Veronica Allen. And she is now allowed to talk.
Okay, great. Ms. Allen, if you could please unmute yourself. We're seeing from our end that you're muted. So you probably can hear us, but we cannot hear you at this point. It would be the little microphone. If you see it. We don't have the ability to unmute you on our end, but if you could try to unmute yourself.
You can move to
Yeah.
Yvonne and then
Yeah.
come back to Veronica.
Yeah, I'm gonna do that. Just giving her okay, great. All right, thanks. All right, so Veronica, we are going to move on to the public comment inside the room, but I will check back with you before I close public comment altogether. Thank you so much. Just hold on and hopefully technology will not win. So, all right, okay, we're gonna go ahead and move, and if you could just state your name too as well, that'd be great.
Hello, everyone. My name's Yvonne Lynn. I am a business owner. I actually built and I currently operate and run Urban Air Concord. I'm also a resident of the city of Lafayette, for the last 3 years as well. I don't have personal interaction with building in the city of Lafayette. However, I have worked extensively with Contra Costa County with multiple permits, different code violations, different code inspections and things like that. I'm working regularly with fire, health.
Hello.
Yeah, hold on. We're if you could just pause right now, we're going with the public comment inside the room and we'll get back to you.
Okay.
Thank you so much. I'll
But
get
we
right.
can hear you.
Yeah, we
Yeah.
can hear you. So just hold on one moment. Keep going. Thank
Okay.
you.
Building and all the other departments as well. I would say that although it hasn't been a joy, it has been actually quite clear what we needed to do, what was expected from us. We got very specific feedback every time we had an inspection of this is what's missing and this is what's needed to make it meet the approvals, and this is the timeline. So we were able to move forward because there was dialogue that went back and forth and the system seemed to work. From what I've seen and observed with this interaction and what's happening, this seems very, very different from that. It seems like there's some sort of bias or there's something happening
hear
that
me?
does not feel like it should be the norm.
So they asked me to hold on.
Hey,
Wait,
Veronica,
please
go on
mute
mute. There you go.
Yeah. There you go.
It feels like
So-
COVID right now.
So, yeah. So I'm not sure honestly what's happening here, but I do know that, and Bennett have reached out to me and said, hey, could you please come and be here like during the inspection, which I was happy to do. And it did seem quite frankly bizarre. I mean, he showed up full body armor. It looked like he had weapons on him. I don't know if he did, but he looked like a very, very full police cars came up, full police cars came and like walked around and then left. I mean, it did seem quite odd. I'm not sure what's going on. I don't know what the reasoning is behind this, but from what I've personally encountered with quite big build jobs, this seems very out of the norm. In terms of my personal experience with the Paynes, we've moved here 3 years ago. Immediately, my kid was in a classroom with Nixon. My kids would never be able to do this. Like they would be screaming in the hallways, right? Like they are the most amazing family, and it's due to how incredible the parents are. They are the most lovely, responsible, heartwarming, and thoughtful people. I am a designer. I've had my houses and my work show up in different architectural magazines. If you walked in their house right now, it is photo and like glam worthy. So I can guarantee you that. I was going to show photos of their house like on my phone. Like every interaction I've had with them has been wonderful and thoughtful, and this just seems odd.
Okay. Thanks so much for your comments. I appreciate it. Okay, and now we're gonna move over to I believe Veronica Allen, and if there's any other public comments in the audience, please raise your hand. Because after Ms. Allen, if we don't see anyone, we will be closing public comment. Okay, thank you. Ms. Allen, it's
Perfect. How much time do I have to speak?
3 minutes.
3 minutes. Okay,
Yeah.
so I'm gonna try to go very quickly. And I'm
Okay.
gonna read the letter that I wrote. I want to make sure that it makes it into this here, the records here.
Okay.
Okay, so my name is Veronica Allen. I'm an attorney who spent many years as corporate counsel in the technology industry, and I now run my own practice. In addition, I've provided pro bono services in fair housing litigation and real estate matters to individuals and families facing legal disputes. I'm also a longtime friend of Ann and Bennett Payne. I've known Bennett we're coming up on 20 years. My family has spent many afternoons at their home over the years. Our children swam in their pool. I have two little beautiful girls who run alongside who run their property along with their boys. They've all grown up together. We've traveled with these people. They are upstanding people. I would never allow my children to enter a home or any land that is unsafe. I mention this because I know firsthand that their home bears no resemblance to the dangerous residence, completely unfit for human habitation that the city papers describe. I was appalled to read this language, yet my personal knowledge is not what moved me to write here. I'm extremely concerned with what I see when I read this record as an attorney. At my fervent request, I've asked the Paynes to keep me updated, and I've stayed very close to them on this topic. In any fair proceeding, the party making an accusation has the burden of proving it, and the most serious accusations demand the most substantial proof. Here, the city has advanced the gravest findings a municipality can make about a private home, an unpermitted dwelling, hazardous electrical and plumbing, a residence unfit for human habitation. These conclusions must rest on documented inspection and professional findings. They have not responded to written requests, and the city's attorney has not produced evidence behind these allegations to the Paynes or to anyone. Their accusations have neither been substantiated nor investigated, as we're hearing here. I'm deeply concerned about the accusations, and I'm wondering if they've been fabricated and contested. And although we contested with evidence, they've been left to stand. I'm gonna skip to this part and let you guys know. I just want to say that the most alarming part of this order is the uncontrolled harm it's causing. On the strength of a finding that it has never substantiated, the city declared the Paynes home unfit for human habitation. These regulations are extending way too far, and they are dealing with way too much on this front. They should have limited it. If they're going to put these people out of a home, and I cannot believe that they are dealing with this. They've put their time, resources, they put family planning on hold. We can't even move forward. We're mostly dealing with this in our friendship. But I want to submit the following for the record. On what documented evidentiary finding and under what authority did the city declare the occupied residence unfit for human habitation?
Thank you so much, Alan. Are there any other public comments online? Okay, not seeing any, I'm gonna go ahead and close the public comment. I appreciate everybody doing that. And we will, if there's, I'm gonna go ahead and they may have some closing statements, but I would love to ask some questions just to get it moving. Okay.
No?
Who
Oh,
would like to start? Guys?
I thought you said you.
No. From the board.
From the
So,
board
yes.
to,
To anyone, to the Paynes, it's our time for some discussion. Any questions?
so you pulled the gas line permit, May of last year? May of 2025. And Fred the inspector didn't come out until January. Why did you, I'm just curious, what took so long? What took 7 or 8 months to have the inspector come out?
I'll go first. We're doing 3 acres. We're essentially addressing a 3-acre property, and we've got multiple things that we're addressing. I can tell you one thing that popped up was our need to focus on ensuring that our insurance did not get dropped, that we did not get dropped from our insurance. And so then we pivoted to actually working on, for example, the 1 acre of 150 trees and cleaning up that hillside there. That took months. In fact, when I called out multiple arborists, they said that, hey, this hasn't been touched, looks like for about 80 years or whatever. And I could spend with my crew down here for about 6 months of just hanging out and working. So we did do some pivots in order to support that, but also we had a year. That's what the statement said. And so we did it within the time frame that was available to us. And if that time frame was different, or if the city had shared with us at that time that, we can change that to less, then we would have. And I think also, if I'm not mistaken, did we actually submit that more than once?
So we first submitted both.
think so.
Yes, in June 2024, we first submitted the gas line
Yeah.
Permit application and the grading permit application through the county.
The city would not have gotten the gas line permit, right?
No.
Right, okay, so.
But I did go online to see
This is the
what
city.
permit activity had occurred out there.
So I guess what I'm hearing is it fell down on your list of priorities.
And also, once we did get the active permit, it actually didn't say, okay, the next step is you need to call in and do a final inspection. The process
Yeah.
wasn't quite clear. It just said your permit is active. And to us, we thought, okay, perfect, we've got a permit.
Yeah.
And then when we went back to the county to clarify, because we were getting all these notices and citations, then at that point they said, oh, now you have to call and final the permit. At which point we tried to figure out, okay, what does that mean? They said you just have to be on site, you have to be over 18, and you have to have your permit card. And that's when they came and they said, oh, we can't do the final inspection now because we need the pothole and we need to test the pressure gauge. We would have had our plumber on site had we known, and we would have dug the pothole. So then they had to come back on site and then we're able to final the permit.
There seems to be a discrepancy on the volume of grading. I heard the city say more than 50, or I should, 50 or more is the right. And you guys are, I think I wrote 45 or something in one of those.
Just to be clear, that's just the excavation. I assume that grading material was placed on site and not off-haul.
Yeah.
Feel free to correct me if I'm wrong. So you have whatever amount was dug up plus whatever amount was placed. So if it was 45, you're looking at 90 cubic yards. If it's 50, you're looking at 100 cubic yards because it's cut and fill.
So
Is my interpretation of it.
That's the first time we've ever heard that.
Yeah.
We've
Totally
never heard that
understand.
from Jimenez or anyone else. Yeah.
So the code says 50 yards of movement.
Right, right.
So
If the code is not as clear as I would like, which
And-
is why I just stuck to the 50 yards of excavation.
And to be fair, I have heard, can't remember where, if it was Lafayette, about off-haul counts on,
Yeah,
off-haul
if you drive
counts.
it off site and
On-haul
then bring it
counts.
back.
That's,
Yeah,
if you take off 50 and bring back 50, that's 100, because there was 100 of movement. But if you're just taking 50 and moving it around your property,
yeah,
I guess
I
I'm-
would have to defer to the county building department
I
on
mean,
that.
I guess
That's-
I'm inclined, there was 50 yards of movement. But I think about that, but what are your numbers? To come up with the
I
40,
believe it's 48.
48.
what are your numbers? What's the math?
So we went actually
Yeah,
and
I think we
measured.
submitted it, actually. We
Yeah,
submitted
and
that.
I
So
responded
you
to
guys
that.
should have that.
Yeah,
And this.
and it
time-
all depends on, it's really the height is the gist of that calculation, because it's between, so it was
5 to 8.
5 to
There's-
8, and admittedly, could you go and get into the minutia of it and do a finite element type analysis where every 10 feet you cut a sliver and do that Sure.
Who would do that?
I'm happy to do that if it would make life easier.
Oh,
Um,
for that.
where did I put that?
Well, so while he's doing that, I'll stall. using. You supplied some pictures and one of them had some dimensions on it.
Right.
And it was 45 feet wide, 11 feet deep. The height varied from 5 to 8 feet.
Mhm.
So an average would be 6.5.
Yep.
Seems reasonable. And so 45 times 11 times 6.5 times a half, since it's a triangle, divided by 27, 59.6 yards. So the information that providing is 59.6. Your geotech guy, in his letter, 45 by 10, 6 to 9 feet, average 7.5, times a half, divided by 27 is 62.5 yard. So the information that's being provided by you so far indicates more than 50, which would then require the permit. And that's why I was asking, you know, what's the math that you've got for something less, because the math you're giving us so far is over 50.
And you're referencing, just so we're all clear.
Yeah, that's
For
the,
This one.
yeah.
Okay, great. Okay.
Good thing, that's good one.
Didn't we provide them with
So,
a updated,
yes, and that was
more
in the,
precise doc? Do you not have that?
I don't believe I
Yeah, we
received
definitely
that.
resubmitted.
so it was the.
It's not in the IDT portal, though.
It was resubmitted, and I believe what maybe inspired that was that we were later told that even though it hung with Contra Costa after submitting it, and no one communicated anything back to us, that I think per BBK, it needed to be submitted to the City of Lafayette's website. And I think even after reviewing that, there was some confusion as to even which location to submit it within the City of Lafayette.
So, yeah, we initially started with the county.
Right.
Yeah,
and I totally get that confusion. You're not the first person who's been slightly confused by that. I do know that a lot of the notices tell you need to talk to the City of Lafayette Planning Department. They're usually very good about helping people navigate the system, how to upload stuff to IDT, all that junk. I don't know who you talked to or how that conversation went. I'm just in the engineering department.
Yep.
Yeah.
And as I said, I'm more than happy to go out there and measure it with you again. I do believe the county code has some requirements on vertical excavations and how tall they can be before you have to lay them back. Or before you have to put a wall in.
Right.
You might have some experience with this too, but if it's a 6 foot tall or even a 5.5 foot tall vertical slope, I thought I read somewhere that it has to be laid back at 1.5 to 1. But your geotech letter.
County or the city, like who are we talking to? As the homeowner,
Exactly.
homeowner builder.
If
You are.
Kind of both, actually.
If it was
Okay.
submitted,
Rating
if it
is
was,
both.
if it was submitted
Yeah,
to the city,
clear it with.
yeah, if it was submitted to the city, so plans are submitted.
Yeah.
The geotech letter is submitted, because I did read that and you said, hey, everything's fine.
Hmm.
Submit that. I would approve that for a grading permit to go to the county. The county may flag it saying, hey, we don't allow vertical cuts, even if it is bedrock. I'm inclined to say I'm okay with it because you've got a geotech letter where he's putting his name and license on that saying this is serving in effect as a retaining wall.
Right.
But you still need to go through the permitting process for it. Because the same thing, if you want to build a retaining wall that's taller than 3 feet, you have to get a building permit.
Right.
So as soon as this thing becomes vertical, I could see how the county would say, that's kind of a retaining wall. I'm not the county. I can't speak for them. So I'm
But
happy
that's
to help you with getting all that stuff put together so we can push this through
Yeah.
the system.
But that's, again, you're not reflecting off of the measurements that were shared to the city in, I believe, January, correct?
I'm
Because there
really
was some-
basing it off of the measurements that are in that drawing. Oh,
This one.
because that was submitted as part of your building
Right.
permit stuff. So if you like, I'm happy to go out there and remeasure it with you. Great
Well,
learning example for the kids on how to calculate cubic yard.
yeah. I think it'd be good if we could get to a point where there's a little bit more trust with the city. And quite honestly, if the last time you've been there, you've shown up with cops and an abatement order that quite honestly seems pretty weak to us and unsubstantiated. Yeah,
I'm happy to just show up as me.
yeah.
So,
So let's
But-
go with your-
some
questions.
question for you is, could they also just hire a surveyor to
course.
provide the volume?
Of course, I'm
calculation?
trying to save them the money of
But
hiring a
just-
surveyor.
Can't
But yes, they
tell
could.
people what to do, but I can ask you questions
Yes, you can.
as an alternative to having someone from the city.
Yep.
Okay. So this is the infamous picture looking into the building that has been identified as the workshop. The
Okay,
workshop photo.
Yeah.
And Gerardo said, yeah, there's a sink back here. So point blank, is there a sink in this building?
Yes, it
Okay,
was there when we bought
Yeah.
it, but yes, that
Okay.
is, there's. a
We have
there.
never said that that picture was inaccurate. We've always stated that in terms of the changes that they're reflecting is inaccurate.
And
So all of that has been there before we closed escrow.
okay.
And that's not a dishwasher. That they're saying.
Well, that was called out, so that's why she's saying
Yeah.
that.
They're
But
claiming.
there is a sink. That's my main question.
there is
Yeah.
something.
So you guys have been very thorough and detailed and granular, which is great. What would have been really helpful is interior pictures of the carport and the workshop. Because that is part of the ADU contention. And I'm just curious, with all your attention to detail, how did that, why did that detail not be included in your submission?
I'll tell you, the first thing is that, again, going back to trust with the city, is that the city has not been willing to provide any specific information about the grounds, particularly for the abatement order. So, and the search warrant. So have the city gone ahead and provided the information that that we had asked for, which was completely fair. What is the grounds for why you are accusing us of XYZ? Then we would have been more than happy to engage. In fact, it got so ridiculous that we end up getting a attorney in hopes of getting that information from them by way of legal means, but the city attorney still refused to provide that information. Those asks have been asked that
That's
we
incorrect.
have submitted repeatedly since November of last year. So multiple months of just trying to get the basics. Why are you accusing us of, for example, not having a flushing toilet? And how is that something that you have achieved?
But just
And
getting,
so my point is that if the city is going to not play fair, is not going to be transparent, is not going to provide information to stand up to what they're accusing us of, I don't know that you can blame us for wanting to be much more reserved. And especially after getting a building inspector to
Yeah.
come in to
but
inspect the
just in
property.
reference to that, but I think the reference is about, and just feeding off of that. In terms of being able to prove certain things and you had drawings and all of that, it would have been helpful to see that there's nothing, that this isn't an ADU. But I do want to ask my question about that is that my understanding is, like, as we were shown from Mr. Chandler, that it was permitted in 91 without a kitchen and without plumbing. And as.
No,
there
no,
was-
that's not true.
With,
It was,
without, no, it had the.
It had
without
plumbing.
kitchen plumbing, so I apologize.
Yeah.
With plumbing, but it did not have,
Yeah.
it said very clearly, and it was a carport at that point.
That
Part
was
of it
not a
was
carport.
You had this, then you had, if we go back to the.
So you're talking about two different areas though, in the same breath.
No, because we saw, so in this,
Mhm.
am I correct?
There is no plumbing in the carport.
No, so here, I know, I understand, but I'm saying, here's the carport,
Yeah,
correct? Okay,
Carport.
here's the carport, and this is what is was supposed to be considered the workshop,
Yes.
Yeah.
correct? Okay,
Yeah.
that's right. So,
With a
and it is-
bathroom and a shower.
Right.
And a water
and
heater.
A
And it
water
is-
heater.
and it is currently, when you bought it, it was walled in like this.
That was not,
The
Okay, so
carport.
this, the carport was not walled in?
no. it
Okay,
was
so
not.
that was
Yeah.
done by you.
Yes.
Okay, I missed that part. Okay.
Yep.
Okay, got it. So, and did you try at any point to get a permit for that, to wall that in?
At what point were we actually called out for that? Was that in December?
I'm
That
not
was
saying,
the
I'm not saying called out for it. I'm asking
no,
as
um,
homeowners.
We didn't realize that we needed to get a permit for that.
Okay.
Because we didn't
And then-
change the structure. We
Right. We didn't change the structure.
Closed
We
it.
thought that we were working within the same parameter of the footprint of the building. And did not get that. But I will also suggest kind of going back to what Yvonne had mentioned, which is that the collaboration, coordination with us as Lafayette citizens, that did not take place. And we found out that that was an issue in the midst of a what we believe to be a wrongful abatement order as well as a wrongful warrant.
So in this, is there anyone living in here right now?
No.
No, it's
It's
Jim,
Jim.
and has always been Jim. For
And
us,
storage.
and storage.
And so, again, I'm just not asking if about being called out on, I'm just asking if you ever went, you did not go because you're saying you did not know that you
Oh,
needed a
no, we
permit?
didn't. know.
Okay,
No.
Yeah.
okay, and I have a question about the gas line. So I understand, and you've said several times that it's capped off, but my understanding and when the attorney had said that even if it's capped off, that because of the pressure, and I understand you're saying that there's not gas going through it at this
Yeah.
time, is that correct?
That's correct.
I see that you were called for, but did you get your permit? You've done nothing with that at this point, or that's the one that you
That's
finalized?
final.
Yeah.
That's final. Yeah.
Okay.
And it's still not connected to the meter.
Okay.
Yeah.
And then the grading. You are saying that you are not aware that you need any permit to grade? Is that my understanding?
Well, clearly it sounds like you don't need a permit unless it's over 50 cubic yards. Is that correct?
Yes.
Yeah, so if it's under 50 cubic yards, you do not need a permit, is my understanding.
Were you planning to do any more after this?
No.
We just wanted that parking space for that area.
I'll let you go ahead and ask your question. We can come back.
So if I understand this correctly, nobody from the city or county has ever been in this structure inside.
Well, when they approved it back in 1991, I guess. Yeah.
This current thing, nobody's been inside.
No.
And have there been any complaints or problems with the grading in terms of neighboring property? Having drainage issues, or anything like that?
None. From our perspective.
One
Yeah, I
about
think
that-
that
one
person
about a fence.
The person that has been complained about.
Is our fence falling over, I believe.
Yeah, I believe you're right.
Her
Yeah.
fence is nowhere near our,
Trust me, I get it.
yeah.
Has that been confirmed? at all?
Yeah.
From the complaint.
Let's see. Andy was the one that was inspecting that, and it says attempted an inspection, but was unable to enter the property. The driveway is blocked with no trespassing signs. So it doesn't sound like he went on site.
Okay.
Yeah.
Okay, that's.
Is that a question?
Oh, I got more questions.
Yeah, go for it.
So you've talked about closing in the wall there on the carport.
Yeah.
So when you compare the elevations of the 1991 permit approval with what's there now, there's actually quite a bit more changes than just filling in that wall.
I don't understand.
Okay. Everybody. So, for example, here is east elevation, right? And it shows you got a door with 2 windows.
Yeah.
That
so
this
that's
is
the,
this is the 1991.
yeah,
Construction.
that'd be the cottage. That'd be here, sorry.
That's
Over here where the police car, yeah, right here.
now it's a door with 1 window. Stuff got changed,
We didn't
We
change
did
it.
not change that.
Yeah, this is how we bought it.
but
Yeah.
I think we could agree stuff got changed. This does not match that.
This
Door,
double door,
Double
and then it
window.
looks like they had a double window, and
Yeah.
instead they made it into a fixed French door.
Yeah.
A French door with that. But
Yeah,
the key is
it's fixed.
it's
It's
different.
not a door.
It's
Yeah, yeah,
different.
yeah.
That's the key. Just
Yeah.
that it's different.
Sure.
There was something done.
Sure.
When we look at so many pictures, so here's the back. This is the cottage, right? As was noted by the attorney, there's some electrical work been done on the exterior.
Yeah.
But there's no lights,
Right,
outlets, no, again, so something's been done.
Right.
Since 1991.
right.
On the back of the porch, you've got 3 windows.
Okay, yeah.
Back of the porch, there's your 3 windows, but it was a door with side lights.
Yeah. So yes, it looks like there are differences between the plans. But when I read through the 1991 permitted, just the permit package, that there was an inspector that came on site at that point in time and said, oh, something about not following plans. However, the structure was still permitted when we bought it.
Yeah,
So I don't know, we did not change.
yeah, this is
these.
nothing that we changed. We never made any of these changes.
I'll give you 2 more.
Yeah, yeah.
So the bathroom here had an outside door accessible to the outside, from the inside and the outside.
The bathroom door, I don't
Right.
know what you're talking
And
about.
so going back to this is where
That's where the bathroom is,
the bathroom is.
and there's a window there.
No door.
Door.
No door.
Yeah.
And then on the back side, over here, here's the back side.
Mhm.
There used to be this sliding door on a track.
That was sliding down
And
there.
it's
It's not.
yeah, but let me just right. See,
Yeah.
Right.
there's a window, but that little sliding door is not there.
Right.
Okay.
Sorry.
So my whole thing for here is just to get hopefully some agreement that what is there now does not match in some ways the approved plans from 91, which means there's been some building, there's been some electrical, there's the sink, so there's been some plumbing. There has been unpermitted work.
I guess.
Okay, that was
The
the
enclosure
whole
part.
point
Yeah.
of,
Yeah. I mean, we just want to make sure that we're clear that we close up the carport
But
and that was the extent of any change
on that structure
Right.
and
Externally,
that you did, that we did.
Yeah,
is externally, because internally, did you add the
We
sink
did
in?
not add the sink.
no,
Yes,
that was already there when we purchased.
this is how we bought it. So we did not change the doors. We did not add doors. We did not add or remove the windows at the cottage. The things that you've called out are accurate, but since they don't normally provide the sort of the list of permits and drawings for a structure or a house that you buy, we would not know at what point the previous owners made those changes. However, we have been straightforward in stating that there was a carport there and we closed it up. Yeah.
So what I'm hearing is that there has been unpermitted work to the carport workshop area. Some of it by you guys and some of it prior to you purchasing the property. Fair statement?
Yes.
So almost,
Uh-oh.
I would say during that 1991 permitting process, that those were the plans that was part of that package. But also part of that package, there was on-site inspection and there was maybe a handwritten note that said, oh, owner not following plans. But still, that structure
Got stamped.
and final with those set of plans. So I'm just saying that was also
That's there,
pre us.
and for better or worse, there's no additional information on that, which makes it hard to do anything with.
Yeah.
And who owns the property right now today?
We did.
We do.
So for better or worse, that's who gets to resolve both current issues, whoever did it. For better or worse. I think that's my questions for now.
But sorry, so if they had put the sink in during that permitting process and then it got finalized after that, for example, or made the changes to the windows that are now like one door. And an inspector said, hey, they're not following plans, but then whatever was done was still finalized. That means that it still comes back to us.
So-
because it deviates from.
In theory, I think you could hypothesize many things. My personal experience is when you do something not to plan and the inspector comes out, they will say, go back to the city, get the changes approved, get the county approved, and then I will come back and re-inspect it. That's my personal experience. Does it always happen that way? Again, you can hypothesize about anything, but under standard operating procedures, inspector would say, field doesn't match plans, go fix it. So,
At what point, is I would imagine that there would be a ton of lawsuits, but at what point, we had actually the guy that came through and did the inspection, he's also been, in the building industry for a while and he's done, I think in there like over 1,500, inspections and what have you, but, one of the things that he said is if you come on site and you do so under sort of erroneous terms, and then you go to basically compare and contrast a home to plans from 30 plus years ago on an 80-year-old home, his guess was that there would be a lot of people in this very same situation having to come up with reasons or trying to share that, hey, I bought the house and now you're saying that I've got to
go back and address all of these prior
But I think that's
things
what,
that are
what was said
different
with the
from
lawyer.
old plans. So I'm sorry.
but that what was said before is that you become responsible, if I'm correct, you become responsible when you assume the property. I think that's what had been said. Is that correct? Yeah, so that,
Okay.
but I mean, that's, yeah, so, but I would say if you had done nothing to the ADU
Mhm.
and you were saying this and had been cited, but you're not saying that, you're saying that you did do the wall, you did do modifications yourself, correct?
Yeah, but I guess what I'm saying is, we're having a hard time swallowing the modifications that you're talking about, because you're talking about a lot more than just the wall. And so the windows and all of these other things, that even the sink, all of those were in the, during the showing, when we came in, during the open houses for the property. So I guess I'm just, it just doesn't seem like a scalable plan, but I guess most people don't have police officers coming on site with warrants or abatement orders to do the level of inspection that the city of Lafayette has chosen to do with us to other citizens of Lafayette. So maybe that's
Yeah,
my
I
answer.
can't answer that. We've only had,
Right.
it only comes to us as a hearing, so
Sure.
I can't answer
Sure.
that piece of it.
Sure.
But I do have one more question before we close. I wanted to, so just so I understand, I've read your timeline, I've read the city's timeline. What I would love, I mean, I'm a homeowner myself, I've been through the process and I completely understand all the frustrations. When you started doing the process, because it sounds like you own something else as well, so maybe you've done, other work. Did you come to the city? Did you come to the planning offices and ask any questions? I'm curious at the very start, where you began, and I understand you were overwhelmed. I heard that about having to clear for insurance purposes. I can totally grasp that. But I'm saying just in terms of doing the work on your house, was there anything that said, let me check if I need a permit for that?
We worked through the
Um,
county first,
yeah.
just because that's where the communication came from. And
Well,
But the
yeah.
communication came, in my understanding, that was after a citation. I'm saying prior, when you started any work, was everything you just kind of went at it? Or did you go, kind of look up how to go about doing it? And did you come to the city or even the county on your own before a citation?
To do the grading that,
Any
for
of the-
example,
Yeah, grading.
why would we need to? You don't need a permit before 50 cubic yards. You don't need a permit for painting or putting up sheetrock or putting in insulation. There's a lot of things that you can actually do.
You need drywall, because you got a drywall inspection, screws,
Well,
so
if you're repairing drywall,
technically.
I don't know that actually.
Oh, just a drywall patch? Okay.
If you are, putting tile down, if you are, working underneath in the crawl space because there have been rodents living there for
But for
40
the
years or
gas,
whatever.
for
the
gas,
gas and
for
the
the
drain.
AD,
Yeah.
for a I understand you're calling it a cottage, but for a conversion, I mean, a garage conversion, carport conversion.
Yeah, I guess where I'm going with this, and I understand where you're
Yeah.
going, is that, and I think that other citizens, Lafayette citizens that I've spoken with is, yeah, there isn't a need to go to the permitting department to ask permission for everything that you do with your home. So to answer your question, no, we did not. We went there once we were alerted that there was an issue. The plumbing, for example, we had absolutely zero expectation to use the gas line. We were doing it because it was a backup. And in particular, we had just gotten quotes for doing our motor court.
for roughly $150,000. And so we were like, whoa, well, if we redo our motor court, we don't want to have to dig that motor court back up after spending 150,000. So we went ahead and we put in the gas lines in the ground with the expectation of not using it.
And that's for the pool? The was for the pool? Or
It goes
direct
for the pool, for
It could go
the, yeah,
down there.
it goes
We don't
to,
know if-
yeah.
If we will use it at all,
Okay.
but
Yeah.
it's there.
I have a question. It's either Matt for you, or I don't know if it's for the attorney. But in terms of, I've read through, as we all have, the escalation of it. What is the city's standpoint in terms of, because you've dealt with these many times before, but in terms of not addressing, because clearly there's an issue with the citations kept getting issued. Can you just explain perhaps the process? I know the officer is no longer here, but how it arrived to the point where we are today in terms of.
I can't speak to the minutia of it or to a large extent the specifics of this case, because I wasn't the one writing citations and stuff. I can just describe what I historically like to do, which is talk to the property owner about the problems, about the issues that we've discovered, and develop a plan for getting from point A to point B to get everything resolved. Seems like that fell apart somewhere along the lines, and it didn't help that we had at least 2 different code enforcement people involved. No, 3 code enforcement people involved on this. That did not help at all. But that's typically what we do is going beyond citations is historically not something that we want to do. We want to develop an action plan with the homeowners for how they can resolve the violations in a timely manner. Usually it's only when we are getting no response to resolving the issues or even communicating that it escalates further.
Can I don't know if it's you, Matt, but explain the May permitting for the gas line that you are saying you had a full year to do, and then a citation occurred. I am confused.
I think I understand their confusion on this perfectly.
Okay, great.
Because the building permit says you have 360 days to do this.
Correct.
The citations say you have a whole lot less time to resolve this citation.
Mhm.
So there's conflicting timelines there. So I understand that. And historically, and I don't know exactly when things were issued, once a building permit is issued, the citation is still live, but we don't issue, or the violation is still live, but we don't keep issuing citation for something that you have acquired the building permit for and are demonstrating a good faith effort to resolving it.
But the citations and the notice came after we had an active permit for the gas line.
That's my understanding. Now, I don't know how that was communicated to all the various people, but I understand the disconnect.
Yeah.
I totally understand how you're like, look, I got 360 days, but the citation says something different.
Well,
Totally
no,
understand.
just to be clear, the citation came after
We had an active.
we had
permit.
an active permit.
Well, that may be true, but the warning and violation were before the active permit.
We had a notice to
no warning.
comply, but no violation. We had
You
notice
got-
to comply.
Usually the way it works is when the county gives you a notice to comply, they give a copy of it to the city of Lafayette. The city of Lafayette then enters it into our code enforcement database and we send you a warning. It's it's a handoff, if you will.
Okay.
Because the
Yeah.
county, all they do is that one and they're done. They
Yeah.
wash their hands of it. Then it becomes our problem.
Yeah,
The city started, I guess, the warning or whatever.
Yeah,
it
the
came after. we
Right,
got
so
the-
you get the thing from the county and then usually within a week or 2, sometimes 3, depending on workload, you'll get something from us, a warning from us that basically says same thing that the county said. And then we run with it from there. And historically, what we want at that point is for the homeowner to contact us and say, hey, I got a warning notice from you and the county. What am I doing? And how do I fix this? We tell them, okay, here's what it is. Here's how you fix it. Go get a permit, go do this sort of stuff. And as long as things are progressing towards getting permitting and finishing it, it stops there. We just want communication telling us, yep, still working on it. Or in your case, we'd love to keep working on it. We've stopped playing with it, but we have some other things. We need to clear the hillside. We want to get the motor court paved. This is all getting really expensive, and we were asking to stretch this timeline out a bit. We're not connecting it to anything. We just need more time.
Wait, I'm confused. If Contra Costa County Building Department is responsible for the gas line and Lafayette City is not, is my understanding.
Technically, the county works for the city. We contract with the county to be our building inspection department.
Right, and so I spoke with them about that, and they said that you guys are usually involved in like planning or like what aesthetics, like what do things look like oh, I don't like that look or whatever. But as it related to the gas line, they were pretty firm that they were responsible for running point on that, as well as the permitting process there. We're working with them, and they have said, hey, you've got a year basically to address it. And then the city of Lafayette decides to come in afterwards in the middle of sort of a conversation and say both, hey, we have no idea what's going on with the Contra Costa County people that you're working with and who is responsible for addressing the building permit for gas lines, which is not aesthetic. You know what, we're going to say that you don't have 360 days. You have whatever we decide that you have. That's how we are looking at this. And based off of our conversations on, I think, 3 different occasions with the county in person in Martinez, it seems to be pretty accurate because they too were confused as to what was going on with the city of Lafayette when we engaged them on that. I think that Sean even mentioned that again when we came out to close it. So it sounds like there is maybe some, maybe even I'll even suggest even strain, but certainly some miscommunication in the handoffs in terms of who's responsible for what between the city and the county, building departments. And again, I don't think that, putting us in the crosshairs for that and changing the judgment, like, hey, you know what, it's convenient for us to judge you on doing it in 60 days versus the 300 days that the county has already said that you have. It seems to me that you should yield to the county and our conversations and engagement with the county should be there, and we should not have to suffer from the city and the coordination with the county building department.
Totally understand your perspective. I still think it's a difference between building permit and code violation.
Yeah.
And you're not wrong. There should be better clarity on, I guess the question I have, and it's a question I'll ask the county, is when you got your building permit, did you tell them you were resolving a code violation?
Of course.
It said on the application, it was
Perfect.
after the fact.
Because that would be that'll be a follow-up question I have for the county, which is when someone comes in to get a building permit for a code violation, what do you guys tell them?
They don't tell as much.
Right, because they should be telling the people that come in with a code violation that the city has given you a timeline to resolve your code violation. Please communicate with them what you're doing and what you've done, because the code violation has its own requirements for timeline. So I will make a note to talk to the county about that, because you're right, they should have. This loop should be closed a little bit tighter so that people have clarity on which timeline they're supposed to be following. Is it the length of time that you have under the building permit before your building permit expires? Or is it the code enforcement timeline?
Well, and I'll also add that there seems to be like it's very selective when the city says that they have access or do not have access to the information that is with the county building department. So what we have heard is, oh yeah, I've got access, but it's hard to get to. And then we've heard, oh yeah, from another person, oh yeah, we have access, or we don't have access at all. So it sounds like the city does have access to the records and information in there. In fact, I would suggest to you that even in our engagements with Mike Moran, it sounded like, in fact, the city has access and visibility into what's going on with Contra Costa County Building Department and the customers there that, or citizens that have submitted permitting information. So correct me if I'm wrong, but it sounds like there is access by the city and code enforcement to see what's going on with the company, or in this case, the county building department, that you guys have contracted to do and some of this work.
We have some access, not complete. So I can pull up, you have a permit, this is when you got it, it's under review. These are the comments that we got on the review. Some of the things that I don't have direct access to that the county has, I believe, are pulling up the plans that they've stamped, pulling up permit cards that they may have scanned into their system. I don't have an ability to do that I'm aware of, but I'm not entirely
Just
sure.
knowing that there's a permit that has been opened would have saved us pain and suffering in terms of having your enforcement officers come onto our property unannounced regularly to follow up on something that has already been submitted with the
Did you
county.
call the code enforcement people to tell them that you've had a building permit?
We didn't know we had to call them. They just showed up unannounced.
Right, but you got all these notices. Did you call anybody at the city to tell them, hey, we have a building permit now, we're working on this?
We told them.
We
when they
told
came-
them when they came on site, and
When
then
they came.
they said, oh, I don't have access to that database, and well, who sent you, Comley? Police Officer Comley? Yeah, not sure who, I just was told that there's an outstanding permit.
But there was something to that. I guess that question that I was hearing is, did you come with these citations? Did you contact prior to doing the appeal? And I saw that you did reach out
Yeah,
to
we
Mike
have gone into both Lafayette, the city of Lafayette.
and the planning
Building
department.
department, as well
And the county.
as the county, yeah, in person.
Just to try
Yeah.
and clarify why is this?
Yeah, I was just more concerned about before we got to
Yeah,
all the scary notices, when we were still in the warning notices and notices of violation. Because I don't see anything in the records that say that you called and said, hey, just giving you an update, I got my building permit for the gas line.
why would we do that? if
Because
we
you have
are
a notice of
engaged
violation
with the
against your property.
county that's asking us to solve it with the county? So we're gonna solve it and address it with the county and then go to the city.
But your
Yeah,
notice of
that's a very-
violation tells you need to communicate it with the city too.
Hmm.
So I totally understand you're getting all sorts of documents flying all around and it can be confusing, but I just want to be clear that we're not psychic and we don't have time to check every single code violation against the county database to see what's going on. To some extent, we rely on the people doing what we ask them to do when they get a notice of violation or a warning notice or a citation, which is communicate with us where we are on this.
Okay,
What-
so
wait,
then let
one
me,
second.
let me just ask one quick question.
Okay.
So as I stated, we had gone into the city of Lafayette on multiple occasions into your right up the hall there. I share with you the citations, and in fact, I believe that I can describe the gentleman and the people who were in that room at that time going through the citations. And in fact, on the citations, there were errors in the citations. And the gentleman had to spend extra time because it sounds like the enforcement person had recorded it incorrectly. After spending time with them, they did not stop and record in a CRM system or a database of any sort my visit. They did not stop to contact proactively a enforcement officer. They did not roll up any information with anyone within your department. They just acted as essentially a help desk, which was helpful. And that was the extent of it. And for the and honestly, it was me going back to the county based off of what they shared with us to then address the permit or the
Okay, so
gas
you
line.
talk to somebody in the planning department, I'm assuming. If you walk in there, everybody on the right.
Just, yeah.
We're all living in that same building.
Yes.
Right, so is
Yeah.
it not, is building department not the same as the permit? You have two different departments?
We have the planning department,
Yeah,
we have the engineering department, one code enforcement guy, that's who lives there.
do you walk
We do
through
not
one
have a
single
building
door
department. Yes,
to get access, and then there's a help desk,
yes.
and that help desk then goes and is responsible for pulling in whatever appropriate resource if they need it or feel they need it, correct?
They pick whoever they think
Right.
is the person who's best suited to answer the question that happens to be there.
Right.
So usually that's a planner. So that's,
Yeah. I don't want to split hairs.
yeah,
I went into your office,
Yep.
right? Where you guys are all located.
What?
And I spoke with your help
About
desk,
when
yeah.
was this, just so I understand the timeline? Was this 24?
I don't have it in
First
front of me
warnings,
at
24,
this
25.
moment,
Okay.
but what I can tell you
Been
is
in there
that
multiple.
it was them that said, county owns this. That's where you solve the problem. What they did not volunteer was, oh, hey, we got to put a stop on this clock. And you've got to do XYZ to do that, or we can do that while you're here. None of that took place.
Did you tell them that it was a code violation that you're trying
I
to address?
handed them
Perfect, okay,
the documentation to make sense of it.
great.
And that's when they started looking through the codes and realizing that some of the documentation in the citation was incorrectly printed.
I have a question, because I'm looking back, I mean, at, citations starting, and warnings in 24. So I know this has been going on for quite a while.
Mhm.
That's what I'm unclear how it gets to where it is now. When, like, did you consider doing an appeal when it was starting to escalate at any time prior to now? Like 2025 is when you put in the appeal in December. Did you ever do I don't say anything in 24, that's my question about contacting the city or saying like, hey, this is going on, this is too much. Because, I see from the citations, it says, this is your notice, an opportunity to correct the above condition, you can do an appeal.
We first got the notices in
I'm sorry,
2020.
which specifically for what
So
specific
like, I'm looking
thing are you
at,
referring to?
I'm going back and just looking at the warning notices.
For what specific
for-
permit?
Gosh, I can go back and look. I guess this was the gas line, and then I'm just saying in general, but I mean, I can go back. There's just.
I don't want to
stuff-
be general at this
Well, I want to be,
moment.
no, I want to
so-
be general in terms of 24. I'm saying in 2024. That's my question. I'm trying to understand the timeline better. Just to be clear, that warning started, as we said, that's how it starts first, warnings before citations. And so if you received a warning, my question is, I think you answered it, so you came to the city office, correct?
Your building department, planning department,
Right,
and
okay.
whatever else that you
Right, I
call
was
it.
just curious if you knew, and you don't know if it was in 2024 when this all began. That's what okay.
Not off the top of my head. but I
Okay,
can
that's
go
fine.
back,
No,
yeah.
I'm totally fine.
Yeah.
I'm trying to piece it
Yeah,
together.
yeah,
So
not a problem.
Yeah.
But I think the overarching question is, did we engage with the city of Lafayette Building Department? And we did.
I want to does anyone have any questions for, the city in terms of the legality?
Actually, there is one other thing I want to
Yeah.
throw out there is that in December of, I think it was the 23rd, maybe the 21st, after we received another
2025?
2025,
Okay,
yes.
thank
I was in your office and I was speaking to Mike
Moran.
Morant. Yeah. And he had stated that, and I had brought the document. Every time I've gone in to meet with you guys or Takasa, I've always brought the documents and trying to decipher what's kind of going on and the perspective. And when I went there, I brought all the documentation, the abatement order and the warrant and all of the citation stuff, what have you. And then I had said, hey, we're gonna want to have a hearing to look at this thing, because this is crazy.
Yeah.
And he said that, and help me with this, but because my blood sugar is really low right now. But he said that, oh yeah, you have plenty of time to protest this,
So,
and you can wait till January 15th to do that. And I was like, huh, really? And I kept kind of chatting with them, and I think at that point he was probably thinking that I was not taking his word for it. And maybe he got a little offended by that, I don't know. But I said, okay, well, hey, hopefully you don't mind, but this is pretty serious stuff here. So I'm going to go home. I'm going to share what you said via email to you and what you stated, which is that we have January 15th, just so that this is recorded. Now, I've been into the Lafayette offices prior with my documentation. And so that was one of the other reasons. It's like, wow, okay, I'm getting misled here. So
To file an appeal, just to clarify,
So-
we had until January 15th to file an appeal, not
Right.
to take care of everything.
yeah, and
Right.
we have that we have that letter. We saw that from
Okay.
Mike. Yeah.
So then, just for the sake of the people listening in, he writes back a day or two later and says, he actually doesn't even acknowledge what he had originally said, which was stated in the email. He states that, what we had till the
December 26th,
26th.
file an appeal for the citation and there's no appeal process for the order to abate.
Now, that's us going into the office, speaking to a high-ranked person in that office to get clarification and to get direction from the city of Lafayette, who provided us incorrect information where we would have lost our rights to appeal. And then had I not sent that email, this would have been yet another portion of the conversation that would not bode well for our family. And so I guess what I'm saying is, just because you've been asking us questions about whether or not
we have gone into your office or reached out to you for help. But I don't think it's fair to suggest that that's the end all be all. And I'm not sure it's fair to suggest that there is no breakdown in the current system in place for this building department here or even Contra Costa. So I guess take that as you think about all of the questions that you are asking us about. Hey, were we just lazy at the wheel or were we active? Please keep that in mind as well. That when we have gone in, we have not gotten consistently accurate information. And that particular example was with someone who was senior at within your organization who misled us.
Does the, Mr. Chandler, do you have anything?
I don't know, and by the way, I don't know if he did that on purpose or not. My guess is
didn't.
that that was not necessarily his intent. But that means nothing to us while you try to barrage us with bills of 38,000 that don't line up with your own billing permitting or your website, what you have
I
published.
just want to give Mr. Chandler, just because we've had a lot of time here, and I just want to make sure that I'm not ignoring the screen as well. If you have anything you want to add.
No, I have nothing to add.
Okay, just checking.
And did you have something? Because I was,
I think you covered it.
okay, all right.
Yep.
Does anyone have any more questions for anyone in this room? Any questions? Well,
What is the land speed of a fully laden sparrow? This is African or European?
okay, great. Are you fine to close the hearings? Everyone?
Sure, they don't.
I'll go ahead and close the hearing. Yes, we're gonna bring it back now to the board to deliberate. Yes, so who'd like to start?
Oh, so,
process?
yeah,
So, yeah,
do you guys, because I need to pee.
Okay.
Yeah, you
guys
guys.
say it.
Yeah, that's the
And
other.
I'm also really low on blood sugar
Yeah,
right now,
that's-
so can you guys deliberate now that we've answered your questions without us, or do we need to keep our family here?
That is a great question. I don't know. I'm gonna ask Sarah.
Aaron, do they have to be here for deliberation or is it optional?
It's optional. You absolutely have the right to be here. At this point, the hearing is closed, so there should be no further questions from the board to the appellants. Of course,
Okay.
if you'd like to listen in, you're more than welcome. And I will actually, at this point, have the opportunity to make a recommendation to the board that, depending on your direction after your deliberations this afternoon, we do need to issue a written resolution. I would recommend that we bring that at another meeting, which we can schedule as soon as possible, but that notice of that meeting will go back out to the appellants and the appellants, and any member of the public would also be welcome to attend that meeting as well.
And you were also saying that we also, if we decide we have the option to, since we'll be coming back again, we could make our decisions. Then if we chose, if we had more that we personally felt we need to dig in, and we also, if we wanted to, we are able to see the property if anyone on the board chose. Is that correct?
That's correct. So if there's anything or anyone you want to hear from, you can request that they attend the next hearing. You said it perfectly. If you want to request that you be able to inspect the property, we could ask the appellants for that opportunity, and we would schedule and notice that as well at the next meeting. Again,
And
you need to attend.
what is the time frame in terms of for the next meeting of whether or not we extend the deliberation?
Yeah, there actually is no time frame for the board to go ahead and continue the meeting. There are some timeframes in the municipal code if the appellant requested a continuance, which is not what's really happening here. But I would recommend, obviously, as soon as everyone is available within the next month, I think would be ideal. We want to keep the hearing fresh, although we are recording the proceedings. But long story short, there is no specific timeline. It's subject to availability.
And just so I'm clear on behalf in terms of everything in terms of the citation, all of that is on hold as well. nothing progresses, correct? They're
As of
not
the
being
day-
penalized by anything being on hold.
Correct. As of the day of the appeal, those violations are now on hold while the matter is being heard.
Okay, okay, great. Okay, sounds good. So yes, just to answer your question, you guys are totally free to leave. We're going to discuss amongst ourselves how we would like to go about whether making a decision today or, waiting, and then we would do a decision as well as the written, we would have it all kind of compile together, correct? Yeah, okay.
Okay. If the two of you want to stay, I can take the kids.
No, I gotta, I need to eat, I haven't eaten.
Sure you
all-
Yeah.
It's fine. Thank you for your time. Thank you for all the
Yes,
information.
appreciate it.
It's nice finally meeting. you.
Yeah,
Nice to
yeah.
finally-
Well, I'm just gonna go straight right now. Get back.
Okay, so I'm gonna bring it back to.
Should be on has council, what the scope of our authority is, in terms of what we can, drop some of.
Yeah, we have correct if I'm wrong, but we have the ability to modify what's being, and all, yeah. And I will say this, I think we can definitely ask any clarifying questions. Considering we have deliberated so long, we've taken in so much information, and we are allowed to continue. I would, and I'd like to hear from you, but I would say that it's not a bad idea to take in all that we've heard. And it sounds like I personally like to hear, we still can get a clarifying information, correct, that Matt was gonna find out from the county about the citation. Would we be able to hear that at the next hearing?
Yes, absolutely.
To talk to the county to find out, that when they went to go ahead and, that the citation, that they were aware, that the county was aware that
They already said the county was aware.
right, but you said you were going to check. And
I was
speak
gonna,
out and-
I was just gonna talk to the county about process
That process.
for the future.
Okay.
Not
Not-
go back in the way
not
back
check
time
to
to
see
find
if
out
that
this.
actually
I just,
happened.
I'm looking at this as an opportunity to fix anything that's broken.
Okay, got it. Okay, thank you. Thanks for the clarification. Just so that I know that we're all on our game in terms of making a decision, is
I'm
that
fine.
okay with
I'm
you?
fine.
I'm fine.
To-
To keep, what's the question? Keep
Oh,
going, or-
if we would make the next meeting, and make our decision at the next meeting, that's.
We wanna have some
So
discussion like
Sarah,
that.
you're suggesting that the motion get approved. If we did a motion today, that it would get approved at the next meeting. If we wait to the next meeting to do the motion, would you then recommend in another meeting after that to approve the emotion?
Yeah, so my intent here is to be able to provide you all with a written resolution that reflects your deliberations and your findings of fact that we can adopt in the meeting. So I would like to get some direction this afternoon, so that we don't continue for a third meeting. But again, if that's what we need, and I could also throw out there if we want to take a longer recess, if people have availability to reconvene in an hour or an hour and a half. I know that might be pushing it a little bit. But maybe that would give us the breathing space to come back and get some direction. Those are my humble requests of the board today.
So good to plunge ahead.
I think it's worthwhile to do a little, at least some conversation now while everything's.
At some point about something.
Thank you.
It would be
All right,
helpful
why don't we
to,
start and see if we're
People-
in. That sounds good. Plunge ahead for a little bit. Let's see. So you want to start a discussion first?
Yeah, I look at this as there's the gas line has been capped. Okay, we're talking about the ADU and the grading. The junk has apparently been cleaned up. Right, so. I don't know, I think that this problem between the county and the city is legit. And I think, I don't know exactly what we could, going on specific fines or anything like that, but I mean, that's where I'm coming from. I think the ADU, what's the remedy that the city wants?
Get a permit.
Get it.
Get a permit?
Yeah.
And if it's not an ADU, fine, just get the changes that were made to the electrical, to the windows, to the plumbing, all that stuff. Have someone draw them up, get it permitted, to retroactive permit, you're done. If they want to make it an ADU, fine.
Fine.
That's actually almost arguably easier.
Easier.
Go and get that permitted as an ADU. It doesn't make any difference to the city. Same thing with the grading. I just want a grading permit. So if they get a surveyor to come out there and say that it's less than 50 cubic yards, and if the county goes along with the idea that a 4 or 5 foot tall vertical excavation does not require any sort of permitting, it's not a retaining wall, it doesn't need to be laid back at 1.5 to 1. I'm fine with that too.
Hypothetical, if it comes in at 49 cubic yards, no permit required, why would even go to the county for cut?
Well, my question is, my concern is, I don't have all of the building codes memorized.
Yeah.
That's not my area of expertise.
Yeah.
Just an engineer doing engineering stuff. It's entirely possible that vertical is considered a wall.
Yeah.
So it doesn't matter if you remove 10 cubic yards. You have what amounts to a retaining wall that is over 3 feet tall.
So
That requires a building permit,
so that's a
regardless. of how-
totally separate.
It's
code issue.
arguably separate
It's
from
separate
the
code
actual
issue.
grading. Yeah,
It's more of a structural issue.
it's
than
more of a
grading.
structural issue.
Got it. Okay, fair.
Now, that's why I said, in my opinion, they've got a geotech that says this is all fine.
Right.
So go get the permit.
County should be fine.
Yeah,
They've got the letter to cover their butt.
right. So the county should just issue the grading permit retroactively and we're done.
Okay.
So as I see it, all of these things can very easily be handled with a retroactive permit. And as far as I'm concerned, normally when someone participates towards the solution of the problem in a timely manner, we waive all of the
Yeah.
citation costs.
Citation?
We just say, that's all gone. Just get this resolved in X number of days, we'll make that all go away.
And somebody told them this, like this, simply say, get the permits and.
I don't know exactly
We'll
if they
see.
were told that, but that is the answer. Just get all your permits. I understand their lack of trust. But by putting no trespassing signs up, it's a prickly position. So I get why Andy wouldn't go on site anymore, because there's a sign that says no trespassing. He has to obey that. I understand their position of Gerardo showing up in a ballistic vest is a little intimidating.
Yeah, because there
Okay.
seems to be something more going on here. That. Will they go ahead and get the permits? Or is it a matter of principle, that?
Right, and that's kind of why we're here.
Yes, just gonna ask Sarah this question. Sarah, do we have the ability for, if we say that all of the permits had to be gotten, if any of the fees were waived, could they all be then, if it's not done within a certain amount of time, then all the citations could stand, including the payment, including the fees?
Yeah, we could do it that way. We could say, I'm not sure if this might be a better question for Matt. If we can guarantee, like, you have to get permits in 30 days. I think part of their argument was, well, it's a whole process to apply and then get finalized. So maybe the trigger is you must apply for a permit and diligently pursue your permit within this amount of time, or the trigger is, these fines kick into effect. And I will say, again, at the pleasure of the board, the city is asking for less than it is entitled to. I'm not understanding the history of the property as well. So the board could also increase the ask if we, want to leverage that, or we could decrease it. But yes, I think that's a feasible way forward here.
And there was a question about the permit fees not being the same as what is publicly stated.
That, it's not the
Is that-
permit fees.
I'm
It's-
sorry,
They
yes.
felt that the fees, that the
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 citation. fees.
citation
I
costs
apologize,
were
yeah.
different than the fees in our fee schedule. And the
Correct.
answer to that is yes,
Okay,
they're entirely different things.
so
The
because.
citations
that-
are codified in the municipal code,
Got it.
not the city's published fee schedule. They're entirely different
And
things.
that's what they're.
And that is
referencing. Thank you.
that I think to some extent is some of their principal problem. They're conflating all sorts of things together.
Mhm.
And I understand why they are. It's because they are not asking any questions of anybody. They're just trying to raw dog their way through it and hope for the best, and that's not working out really well. So I would suggest that we try and try and rebuild the level of trust, try and get us back to solving the problem at hand rather than being punitive about the past. That doesn't seem as helpful
But
as
it can
trying
be
to.
punitive in the future if things are not
Right,
met.
so we could, for example, say, and this is what we've done with other cases, tell people, Hunsaker Canyon is a good example of what we did. Aaron, you may remember that one, where we told them, great, it's a new owner. You have a year or whatever it was, I want to say it was a year or 60 days to move forward with it, show good faith efforts. So in this case, we could say you have 6 months or whatever timeline you want to develop plans and apply for the permits for all of the work on the property that has been identified or is not shown on the, what was it, 1991 plan set. If you want to be more gory detail, you can, but grading permits plus all of the unpermitted work in the accessory structure. You need to get those plans into us within 6 months. Failure to do that will result in restarting the citations, and the citations will not be forgiven. If you do get those into us and you diligently pursue resolving this, so getting building inspection and all that, we will waive all of the citations that have been accumulated. And I don't know how we get rid of the stuff that has been recorded on the title or how that gets resolved, how the notice of, what was it, abatement gets noticed of unabatement.
I could do all that. Once the violations are corrected, we can withdraw that notice to abate from.
Okay.
record. But if I could just suggest something as well, in terms of them applying for these permits, and then working diligently, in my experience, that generally doesn't go very well, because they can apply, ask for extensions, or they apply and the permit application is defective. And then we get into this agreement of let's keep extending it out. These are retroactive permits, so the work's been done. They just need to go get it and get it looked at and approved. So I would suggest maybe a finalization date in terms of you have to submit the application and get it finalized by a certain date. Otherwise, citations would begin to accrue or become due, something like that.
So we could give a very, very long,
It would have to be long,
Finalization
because
date.
I do know how it can take.
so we could say finalization by within a year.
Because then the county.
But you
would
have to,
do
you
it.
have to submit
Submit.
everything to us within 6 months. You have to final everything within a year.
Mhm.
Yeah, I think again, it's pretty simple, to be honest, and it's already been done, so it's kind of just looking back, hey, did you do it correctly? Yes or no, stamps.
Right.
approved.
It's
So
gonna be, you gotta go find someone to prepare the plans,
yeah,
and that will take time.
that takes
I
time,
mean,
yeah.
but 6 months is plenty of time to accomplish that if you do it with a sense of purpose.
So
And you're correct, it would go even faster if it was put as an ADU.
I don't know if it would go faster, but there would be less future questioning, let's put it that way, because now you can do whatever you want with it. You've put a
Yeah.
kitchen in it, you're
Yeah.
good.
Right.
But if they say it's not gonna be an ADU, and the building inspector goes out there to inspect
It
things,
is.
and he sees a stove and a sink, and now it's an ADU, and you're gonna be in trouble again. So my advice to them would be, make sure you're getting permits for what you have.
Good way to phrase it.
And if you want, and now's the time, if you want something more than what you have, go for it, add it.
Right.
Now's the time to do it.
Yeah. Bob? You're too quiet, Bob.
Too quiet. I
It's,
was pretty vocal before. So I guess where I'm landing is, looking at the citation. And I'm gonna go backwards kind of. The ADU part, I would lean towards the appellant strictly on a procedural basis because they were not provided with a notice of violation. But either the city, the very next day, submits a warning or NOV to them, because we know that it is an unpermitted ADU, or as part of the motion that we're like, okay, we found for the appellant on that, but you've got X period of time.
I'm not sure I follow because they.
Yeah.
They basically saying, because you didn't follow the procedures for all the things that were cited for the ADU, they were never given a warning.
Right, oh, got
Those
it.
should be
That's
wiped, those should be wiped out, but now we know they're there, so they should get a warning notice. I would suggest you figure out how to bake that into your decision.
Yes.
Bake
Yeah.
the warning notice
Yes.
into the decision and just
Yeah.
say we agree with you procedurally that you shouldn't have been given that. Those fines associated that will be removed.
Yeah.
Period.
Move those.
But however, it is clear that work was done on it.
Yeah.
So you do need to obtain a building permit for that. And that needs to be accomplished within the 6-month timeline, the same as the grading permit.
Yeah. And so in terms of a procedural fine for the appellant, the same thing goes for the hazardous plumbing, hazardous electric, dead vegetation, and junk, because they never got the NOV.
But the hazardous plumbing is based on, I thought you clarified it was gas. I know.
And that makes the whole thing moot. The gas.
Exactly, the gas was permitted.
Right, and
It's fine.
I guess I would go with, since the gas is already finalized and approved, the vegetation is already cleared and done, the junk is already cleared and done, they just get dropped.
Right,
And all the
exactly.
fines associated
Right,
with it
those-
get dropped.
Those items get dropped. 3708 grading, which is, like I say, I think applies to the permitting agency, not the,
Agreed.
that would get dropped. Again, the hazardous mechanical, I'm kind of like
Which one's that?
the
Which number though?
California Health and Safety 17920.3F. That, I mean, I understand where Harada was coming from, but it was kind of nebulous, saying, well, because there's this, I think there might be something. And that just seems kind of,
Oh, I see this one. The all mechanical equipment, the third one down.
yeah,
The third one down on the citation, on the December, because this is all of this, the hearing is based on the December 12th. I mean.
right. And so,
Citation 342.
I guess think I'm gonna fall on the part of the appellant on that one, only because the next one, 3-304 building, I would lean city on that, because clearly there's been building stuff and they do need to get the building
I mean,
permit.
the one above it.
The 3-3,
This
yeah, the
one,
building
okay,
code.
Okay.
That, I think we all agreed that there was unpermitted building and they have to be able to take care of that. And again, that's part of the discussion of 6 months or whatever the thing is. And as part of that process, any mechanical, electrical plumbing in the structure will also get permitted, inspected. And so because that will be inclusive, you know, finding for the appellant on the,
Well, this one gets to all three of the issues that we.
right, yeah, so saying, okay, forget 3F because we're gonna take,
It feels like some of these citations are doubling up,
right, yeah,
so they should only have one
so I'm just gonna
for
say,
each thing, not two or three for each thing. Is that kind of where you're going with that?
well, I mean, technically, you said, oh, you know, I guess you could say, okay, we're gonna fine you for 3-304 building, 305, if that's right, 306 plumbing, 307, do all that stuff, but in this particular case, they're gonna have to get the retroactive permit that covers everything.
Yeah.
It's gonna be taken care of in allegedly a timely manner.
Well, I think what we want to do is still provide a we don't want to just summarily delete everything just because there still needs to be administrative citations that are appropriate for the things that were found to be in violation, and also so that there's a reason for them to get this resolved. I mean,
So
the abatement order and stuff like that should be reason enough.
Is it just this is a question for you, is it just a permit, or do they have to do, isn't it some kind of variance or
I don't think they need a variance for any of this.
Okay,
But I'm aware of, when they come in with their plans to the planning department will tell them if they need a
okay,
variance.
got it.
But my understanding is they didn't change the footprint of the building,
right,
so I don't know why they would need a variance for any of that. The
Right.
grading, as long as the grading is not within 4 feet of the property line, they're probably okay on that one and don't need a variance.
a conversion ADU is pretty straightforward in theory.
They are in the
Well, just
hillside
because they,
overlay district,
it was
so.
written that it was to be deconstructed.
Well, it's
I mean, that's,
permitted or removed.
yeah, it requires.
Yeah, that's fair.
Yeah.
Your
Permitted. shall be-
choice.
Mhm.
So yeah, the grading and building, I think what it sounds like are the two that they need to do, get the permits, whatever the language is and the incentives are to, you know, if you hit these benchmarks, then we'll pause all charges. And if you hit these benchmarks, we remove them, whatever the incentive is.
Yes, and then, but if it's not done, so what we were saying, what kind of had coalesced was the 6 months to actually get the permit and then the 1 year to be finalized. Is that?
And if you miss any of those deadlines, citations begin again,
Yeah,
and the past citations are not forgiven.
correct. Yes.
So I think, just for my purposes, we are looking at 3-701, which is the grading violation at the very top of the December 12th citation. The next one down, 3-304, which is building code for unpermitted construction, including the gas line, but not limited to. We've already discussed the gas line is permitted, taken care of. Where did we fall on the hazardous mechanical? Bob, I know you were kind of like, I don't know about that.
I think I would fall on the side of the appellant only just to get rid of that line item.
I agree.
Because
That's not the topic.
as part of their inspections of the unpermitted work, you know, the county's gonna be looking at electrical, plumbing, mechanical, so on the
3-304 is really the overarching encompass. Sorry, 3-304 we're saying is the encompassing violation.
Yeah,
Sorry, I cut you off mid-thought.
That's correct.
Seems to me like the only two sets of fines that should stay for future use, for lack of a better way of describing it, is grading and building.
with building, removing the gas line
Right,
language,
but-
that's no longer,
but it's instead of having, what, 8
right, it's just these
separate
two,
things?
right?
It should be building,
Yeah.
which covers everything associated with the building.
Correct. And
And
grading.
grading, which covers everything associated with the grading.
And then ADU.
Well, that's building.
Okay, and so you're just talking about, no. What are we talking,
Because it's not necessarily an ADU.
right now
It's a
it
bit,
is,
well,
because we all agreed there's a sink in there, and that's what planning says, a sink
Well, you
outside the
need-
bathroom.
you need a sink and you need a kitchen, so you need a sink and a stove,
So
I think.
last
You need a kitchen.
I had conversations with the city that the minimum trigger to require an ADU is a sink outside the bathroom. Because then you can just plug in your appliances and you're good to go. And so they're like,
Alright.
once there's a kitchen outside the bathroom, you're gonna have to go through the
I
ADU
shall
process.
defer to you.
Now, that could be wrong, I often am, but that's my understanding.
Yeah, my own understanding is you needed to have a kitchen, but how you define kitchen is not very well defined. So, yeah, okay, three things:
Yeah,
Yeah,
building,
building,
grading,
grading.
ADU.
but there are two different, there's grading and grading permits in here.
Right, so
So we're just gonna see, so
that's what I
Well,
mean
that
by there
one's
seems to
invalid.
be
Right.
doubling up.
we're just gonna do this. We're just doing the 3-701, the 3-304. And
CHSC.
The ADU zoning.
And the ADU stuff,
Zoning.
you're gonna do that as kind of more of a warning, hey, you need to resolve this.
Or else we'll start.
Or else we'll start citations on that at the beginning of that at the end of that 6-month period.
yes. So those three.
Yeah,
So just so we're clear, so 3-701, building code 3-304. And then the final one on the citation, which is 6-563A, the ADU zoning.
except we're not gonna actually reference the ADU zoning thing, we're just gonna say you've got time to get going. Right?
Right.
And so we wouldn't actually ding them with an ADU code thing until the end of that 6 months or whatever it is. So at this point, the instructions are, you need to get that ADU permitted within this.
Well, you need to get all of the things in that building permitted. If any of those trigger this being considered an ADU, you will need to modify it so it doesn't trigger being an ADU or apply for an ADU permit.
Give them the choice, fair.
Okay.
Because they
But-
could just take the sink out.
They could.
That's
And then
true.
it's-
And then it's back to being a workshop.
Yeah,
So it's gonna be the first one here, second one, and then.
Yes,
and
first
e-
one, second one, and then,
Either or sort of thing.
yeah, so, right, for the last,
Hmm.
exactly.
The six.
And
five, six,
because
three.
it is our understanding, correct, from the 1991, that the bathroom, that was permitted, it was on the plans, it was, so we don't need to check the plumbing on that.
nope.
Okay.
Okay, so I think that leads me then to findings of fact, which I think are really straightforward because they are based on these violations. So we talked about they do not have permits for the grading, for the expanded plumbing, which they did admit they have a sink. There were no permits pulled for enclosing the covered car parking. Let me see what else would be key here.
I mean,
Electrical,
Electrical.
the electrical on the ADU, or on
Yes.
the
Accessory structure.
accessory structure.
The workshop structure. Well, and then both structures had at least, exterior revisions. Replacing doors or removing doors or that they're saying they were done before they moved in, but yeah.
Yes, and I do have that code section. There is a specific code that I will reference from the California Civil Code talking about successive ownership and the responsibility of curing existing violations on property, even if they were caused by a previous owner. So that'll be wrapped in as well for their awareness.
That fit well with everyone?
Yeah.
Well, that's, and that's feasible from a city perspective, just so, yeah,
Just your helpful.
I know. Yeah, just, yeah. All right, so then I guess what we have to do is, we will schedule a follow-up meeting, correct? So that we can, you will be sending us what, the written part of what you are gonna put together for our findings, is that correct? And we
Can you
have to
all-
meet and do that.
They also appealed the notice and order, so can you guys also review that and make findings on that?
Thank you. You mean the, yes,
Oh,
the
yes.
legal notice in order to repair or abate, that's
Yes,
correct? Thank
December
you.
16th, 2025, yeah.
Yes, correct. So we,
So let me, give me a moment to tell you all what would be consistent between the two.
yeah,
Let's see. So. ADU 6-536, that is present in item number 2, item number 3, item number 4, 5, and 5. So that's the ADU. Let's see, grading. I'm not seeing the grading explicitly mentioned in here. And building code. These are mostly health and safety violations. Okay, so that's the overlap for our information.
Well, I guess. Do we just completely rescind it because? The notice to repair or abate, there's no references to. 3-701 or 3-304,
only the ADU.
only the ADU, and we're like,
And we're not sure.
we're giving them a fresh start, so to speak, on the
Yeah.
ADU.
Just send the whole thing.
So we just rescind
Yeah,
the
just
whole,
make it simple.
I'm okay with that.
I'm okay with that.
All right,
Everyone in agreement?
Yeah.
yeah.
Okay, we're okay to rescind it. Let's do this.
Is there anything in the notice you would like to wrap into the decision similar to the ADU warnings? To, keep that standard of, based on our findings of fact, these appear to be violations on the property, you must remedy them. Or perhaps the city will issue a new legal notice in order to abate.
Yeah, I would do
If it gets that far.
if it gets to that point, I think we'd have to do a new one and tie it to the things that we found in these findings today. That we
Okay.
were very clear on.
Don't give them a reason to spin out, right?
Yeah.
Okay, and we said, I know it was thrown out there, a 6-month to 1-year timeline. Aaron's comment was that we could probably go something more aggressive. Are we solid on the 6 to 1 year?
More aggressive, yeah, I think in 6 months to get the permit, and then 1 year it was to final it. Am I correct? That's what I decided on.
I'm just like, 6 months,
To get the permit.
break out in a cold sweat.
But
Because so much of it is outside of your control.
Right.
I think it would be more. I think the 1 year for doing the ADU permit, the grading permit, I mean, 1 year seems reasonable instead of.
So don't tell them you have 6 months to get your permit in, just say you have 1 year to get this figured out.
I might do
Final.
more front end that you've got X time to submit a complete permit application. To force them to get that, because they seem kind of procrastination-ish. And that if there's something, you have 2 months or 3 months to submit a complete permit application for,
that is it could be a short timeline, as you said, if they have to get drawings, if they choose to go the
That's
route.
why I
of
was a little
AD,
worried
that's my-
about
That's
3
my
months.
concern.
Cause they're starting from zero on this, so it could take them a month or two
To find
to
someone.
get all the professionals lined up and actually working on it.
Yeah,
right,
it
so
does.
they might not submit for 5 months, so saying you need a
Right.
permit in 6 is also unreasonable.
Okay, maybe we need to say you need to submit a complete and approved application package within 6 months.
An application
What do they
package,
do?
we'd
So
have
they-
to state that it,
So
What
you
entails.
have to submit it. The city has to have approved your application as complete,
mhm,
and then it goes to the county. So at 6 months, we need to have approved it as complete.
Okay, so for the workshop ADU, if they choose to keep it as an ADU, they need to be able to get the plans drawn.
not an AD, well, I mean.
Let's just say they keep
Let's say
it,
they're
Let's
gonna
say
make it an
make it
ADU,
it makes total sense to keep it as an ADU.
or even make it as an
Make it,
ADU.
it's
Um,
legally.
they'll complete, they gotta get it drawn up, submit it to the city. City has 30 days to review if it's complete or not. So that could take, 3 months. But once it's complete, it's like probably gonna be ministerial.
Right,
And so in 4 months, they could have a completed, approved ADU thing. But it's not until then can they take those plans
to the county.
to the county.
Mhm.
That's why I'm saying, give them 6 months to achieve the city has
Plan.
approved your plans, you can go to the county now. But they've, in past, they've gone to the county and submitted stuff, and the county has said, hey, here's what we need, and they haven't responded.
Mhm.
So that's why I think then the next thing is you have 1 year to get everything finalized. I think it helps with the,
Do they have at that point, would they have a planner assigned to them or no, because these are just over the counter?
chances are this isn't gonna require a planner be assigned to them. I mean, initially, yes, there will be a planner assigned to them
Just so they have
to
someone.
help them shepherd it through the
That's my
project.
question.
Ultimately, either I will see the plans or
Okay.
the other engineer, Lori, will see the
Okay.
plans and review them.
Okay.
I don't see us being terribly excited about the ADUs or the accessory structure, getting that all.
I'm looking to
Codified
ensure that
grading
it doesn't go through the cracks. If they have questions, that there is some kind of, it sounds like there may be a little handholding at this
Right,
point.
I mean, the planning department is the one that's supposed to hold their hands when they actually go through the
through.
process.
Correct.
Now,
Okay.
of course, I will tell them. If something gets stuck or you feel like it's not moving fast enough, call me.
Okay.
I'll shake it free one way or the other. I don't like you.
Okay, so I think I'm comfortable with 6 months within to get it, what you're saying is to submit it and have the stamp from the city
Have it be submitted and
and
deemed complete
complete.
by the city.
Yeah. Okay,
I think that's the terminology.
yeah,
If they choose to go the ADU route, all city permits within 6 months.
City approvals.
approvals.
It
We're not-
needs to be deemed complete by the city of Lafayette
Get
within
city,
6 months.
get city approvals within 6 months for grading,
Building
building,
and
and
ADU
if
if
they,
applicable.
Correct.
if they choose.
Yeah,
Right,
if applicable.
exactly.
Okay,
Cause they could take out their sink. They
Right.
could choose to do that and it's really just a glorified shed that they still need. It has electrical, so it still needs a permit.
Yeah, it's a structure.
It's a structure, but it's not,
It's not an ADU. It's
Um,
up to them how they wanna do
Yeah,
it. I mean, and
Does somebody explain all this to them, like taking out the sink? I mean.
um,
well,
that's up to
No,
them
that's
to,
They have to figure.
they
it out.
need to, They need to talk to they need to talk to an architect or an engineer to help them through the
Okay,
process. It's not necessarily our
Yeah, we don't put that,
responsibility to
yeah.
design stuff
Yeah.
for them.
Well, and it would have to, we don't know what, in terms of when they do have it looked at in terms of an architect, if it is structurally sound. I mean, we have to, it hasn't been proven, it just was a carport. They put the walls in.
Right, and I don't know
Yeah.
what else they put in.
I know,
When
I
they
know.
put the wall in.
Right.
Are there electrical outlets on that side?
Right.
If there aren't, I believe code requires you to have electrical outlets on every wall.
Every
Am I
12
correct?
feet.
Yep,
Yeah,
yeah.
so,
In the corner.
so they have to have electrical in there if they don't. So, and if they do, they did it without a permit, so
And if
you're
there's
kind of.
water, there'd be grounding and.
It's, so
Yeah.
there's all
Yeah.
sorts of things, so
Okay.
that's why it says, go get all the stuff you need, but
Right.
step one, go hire all the professionals that
Right.
you need to help you through this process. Don't try and do this on your own. This is not your expertise, and I don't think we can include that in the notice. I mean, I think the legal document simply needs to say here, because this is the part that I think I understand their confusion. They need very, very clear, specific guidelines. Thou shalt go get a grading permit or demonstrate that you don't need one.
Mhm.
Go hire a civil engineer, survey it, come up with a calculation of what the earth movement really was.
Mhm.
Building permit, you did all these things to it since since 1999. Go document all the changes, have somebody draw it up, go get
Correct.
whatever permits you need for it.
Correct. And I think 6 months, you can get the plans in there. I mean, that's not unreasonable.
I would think so. I mean,
I do, is there a leeway? I mean, I do, that is. They have to find someone who's willing to make the plans pretty fast.
right now, I will say, if people call me and they go, oh my God, I'm coming up on my 6-month deadline, it's gonna be in a week, and my architect says it's gonna take 3 more weeks to get this done.
Right.
Just communicate
Sarah,
with
that's
me.
my question. What is, if we put this in terms of time frame, what is the legality of that? If something comes
Yeah,
up.
do we have
they
any
have-
flexibility?
Yes.
Flexibility, we can bake that into the decision. Like, for example, we can say extensions may be granted at the sole discretion of sorry, Matt, I don't know your title. At the building manager, building or
Engineering services manager.
there we go. And so then it'll be on a case by case basis that would allow some flexibility and some extension, but would also allow us to hold those dates firm if we wanted to. I also wanted to just pivot. I apologize for the interruption, but looking back at the notice in order to abate, we can rescind. Unfortunately, if we do, or maybe that's me interjecting too much, the consequence if we do partially would be that the city would not be able to recover its attorney's fees and costs, which is one of the strategic reasons why we do issue notices of order to abate. And it could potentially open up the city to having the appellants request recovery of their own fees. So that's just something to consider. Another viable option could just be amending the notice. So instead of entirely rescinding it, we could still potentially stick with those ADU notices.
2, 3, 4, and 5.
Amend that language again to align with the order to state, you must either get these permits, figure out what you're doing, remove the sink, get the permits, get an ADU permit and make the entire structure an ADU. That way we would not be entirely rescinding the order. Just some additional context there.
And then the time frame, because in the order, it does talk about the 30 calendar days.
Yes,
So-
we would align those two timeframes, I'm imagining, between the decision and the order. And again, if we do end up getting compliance, then at that point we would terminate the order for not a rescinding as in we're taking it back, but a termination as in these have been complied with and therefore we are taking this off of title.
it becomes negated. Okay,
Mhm.
so, and that would also be, that would be written out for them as well, in terms of that we would just, we would, if this was all, if everything, if they comply with everything, and we are saying we make the modifications, then we have in our language that this order would be terminated, correct?
Yes. Mhm.
Okay, so we're clear, okay. And we would be looking at the ones that apply. We only saw for the ADU, as you mentioned, was 2, 3, 4, and 5. Is there anything that you guys see?
No.
Otherwise, because it was the general lack of maintenance, unsafe building, faulty electrical wire, substandard building, and unsafe building general. Yeah, the only thing I do have one question, number 6, for the unsafe building, faulty electrical wiring. Would that be if we take that out, but it's found in the accessory unit, that would be covered under 2, 3, 4, or 5? Because as
Yes.
Matt brought up, they might not have the electrical that they might have put something in that shouldn't have been there, and we just don't know.
Mhm.
So number 6, that's also fine to remove. Just wanted to.
I believe so, because I think the unpermitted construction is what really encompasses the
All of
additional plumbing, the additional electric, the enclosed, structure.
Great. Okay. Well, based on that new information, I am comfortable modifying it.
Okay.
Rather than rescinding it.
Fair.
Is that fine with you?
That's
Okay,
fine.
great. But then I do want in there that we should terminate it after it's all completed, correct? That we would terminate the whole order.
Once.
Once it's all been.
If they've met
completed.
all their
If they've
obligations.
met all their obligations.
Everything's final. Yeah,
Yeah.
Okay, let's just,
legit, fair.
because I know it's an issue on the mortgage, and I heard them. Okay.
And we told them that this whole video would get posted within a couple hours of being done, but I think Therese is probably out of the office by now. Kyle, I don't know if you know how to post this. Okay,
Oh,
so just make sure everybody knows, Kyle's gonna post this whole thing to the city's website. Is there, anybody see an issue with that? It's a public meeting, so.
I would just check, their kids were in the video, so, I would just make sure, maybe ask them first, otherwise we'd have to redact that, I would say.
Yeah, and I don't think we have the ability to redact video.
Or blur it out.
So,
We could send it to them directly.
we don't have a mechanism for doing that, because this is going to be an enormous file.
Got it, okay.
Yeah.
An unlisted.
Aaron or Sarah, would you mind reaching out to them and letting them know that we have the video, but we don't want to post it on our website because it has their kids in it, and we want to be sensitive to that.
what's the issue with kids?
Minors.
Underage minors. Can't-
They're-
Yeah,
Hey,
I
so
can request that we either get their consent in writing to post the video, or we get, an acknowledgement that this is not going to be publicly, available because of those concerns, and then we can provide, is it feasible to just rewind like 20 years ago and give them a thumb drive, with the video on it?
We
do it.
we could find an alternative method for getting them it. We could dump it into a Google Drive somewhere and have them download it, but
Or just a Dropbox. Yeah.
or a Dropbox, but since we told them that it would be online, if someone could reach out to them and say, we want to make sure you are okay with that before we do it, because your children were in the video.
Okay.
Even though there's no expectation of privacy because it is public space.
Yeah, I'm mostly concerned with making sure that they get a copy, that, the city retains a
Yes.
copy, and that our office has a copy. Otherwise, we publish minutes, so we will have a public record of the hearing, and we have the admin record that anyone can request. So I will reach out and get that clarification from them, and we'll figure out a way to get it to them.
Thank you.
Yeah, that sounds great. Thank you very much.
It'll be a big thumb drive.
Yeah. All right. Does anyone have any further questions or comments before I close the meeting?
Reschedule.
Yeah, so we will work with staff to schedule.
Yeah,
I'm
so
assuming.
I'm sure Sarah or Aaron will send me something saying, here's the document. I assume you'll send it to the board also, asking for comments on the document. Send those back once the document is all good. Then within I would guess a week of that or thereabouts, we'd want to convene another meeting.
Okay, and I would say that the document should be part of our agenda. So this is more of a staff side situation, but whether that's a 72-hour agenda or a 24-hour, if it's a special meeting, we can just do a 24-hour, but we should expect to publish that in advance.
Yes.
Like a date uncertain, is that
Yeah.
proper language?
Well, we need to find out,
Schedule.
once we get everything cool with the document, then it will be a matter of talking with the three of you to find
Okay.
out
Sounds good.
what day works. And it might be just in the interest of being nice to the property owners, we should include them in that conversation too, to make sure everybody can attend on that day.
Okay. Can I request that the motion be not only to continue to a date to be determined, but that the board direct the attorney's office to prepare the resolutions consistent with our discussion?
Yes, who would like to make that motion?
I'll make that motion.
Do you know, can you repeat it? Or,
Okay.
What she said.
Yeah,
what she said.
That'll do.
that do?
And I'll second.
Great. Okay, all those in favor?
Aye.
Aye.
Okay, great. The motion passes. Thank you so much to everybody for this long extended meeting. And the meeting is adjourned.
Adjourned.
3:27.
Wow.
Save and print.